So it's just sort of a basic briefing.
It's like for the last of the campaign, also it's different issues, sitting down, it's just the last of the questions.
Okay.
That's it.
Good morning. My name is Andrew Schultz. I'm the chair of the Board of Ethics and Campaign Practices. I'm going to call to order today's meeting for Thursday, November 9th, 2017. We have a little bit larger crowd than we're used to here today, so let me just remind people there is a sign-up sheet. It's on the rail right back here. You're not required to sign in, but if you would like to, please do so, and the city clerk will collect that at the end of today's hearing. Let me start with the review and approval for today's agenda. We have one substantive matter on today's agenda, and that's the evidentiary hearing in Board of Ethics 08-2017, Wayne Johnson versus Tim Keller. Can I ask for a motion to review for today's agenda?
I move to approve.
Great, thank you. A second? Second. Okay. Assuming there are no opposition, the agenda will be approved. We also have in our packet the minutes from the October 25th, 2017 meeting. Those were sent to all board members before today's meeting. Can I have a motion to approve the minutes from the October 25th, 2017 meeting?
Motion to approve.
Great, thank you. And a second?
I'll second.
Thanks. Is there any opposition or any corrections to the minutes? All right, then the minutes will be considered approved. So let's turn then to the evidentiary hearing in 08-2017. I know the lawyers who are representing the parties have heard this before, but given that we have a number of other people who are here, let me just spend a minute or two talking about what the purpose and the scope of today's hearing will be. The evidentiary hearing process is very specifically regulated by the board's rules and regulations, specifically Section 6, Article H. The purpose of today's hearing is to provide the parties with a full and fair hearing. That does not mean an unlimited hearing, and it does not mean an unlimited amount of time to plead their case. As chair, I am expressly authorized under the rules to impose reasonable limits on the number of witnesses and the nature and the length of the testimony and argument to be heard, and we're going to come back to that in just a minute. Let me talk a little bit about the nature of the evidence that the board can consider and that the parties can present. We are not constrained by the rules of evidence. I'll remind the lawyers about that, as last time we had an evidentiary hearing, there was a good deal of objections for things that I can't rule on. Just to make sure the lawyers remember that, I wore my blue suit, not a black robe. So, the only constraint that we have is that the evidence cannot be irrelevant, immaterial, or unduly repetitious. The evidence must have a direct and substantial bearing on the case. And again, that's consistent with the notion that the parties get a full and fair hearing, but not an unlimited one. Let me also remind the parties and the council about the nature of the board's powers that have been granted. We are a board of very limited and constrained powers. We can impose fines of no more than $500 for each violation of the election code that the board finds. We cannot remove a candidate from the ballot. We cannot rule on the validity or the constitutionality of any portion of the election code. So for today's hearing, on October 5th, 2017, I set out an order to both council regarding the conduct of today's hearing. I'm going to read the relevant portion of that because this is how we will proceed today. The evidentiary hearing shall be held for a total of 3 hours from 9 a.m. until noon on November 9th, 2017. The time shall be divided equally between complainant and respondent. During their allotted time, each party will be afforded an opportunity to make opening and closing statements and to present evidence in support of their respective positions in the form of witness testimony, documents, and recordings. Let me stress that means each side gets 90 minutes, no more, no less. As Mr. Urias will recall from our last hearing, if you are in mid-sentence and you hit your 90-minute mark, I will cut you off. It is up to each counsel to measure their own time. I will keep you informed as the hearing goes on. You are the judges of how you will spend that time. So, let me also remind both counsel, you have submitted a number of preliminary motions and matters. If you want to spend the time to argue those before us today, that's fine. That will cut against your time. We are here for 3 hours to hear this matter. You are the masters of how you will spend your time. So you can determine for us during your allotted time how you want to spend it and what you want us to decide. The order that we will follow is the order that is set out in our rules and regulations. The complainant will present his case first. The respondent will be afforded the opportunity to cross-examine each witness that is called. The board will also have the opportunity to ask questions of counsel and of any witnesses who are called to the stand. The respondent will then have the opportunity to present their case in a similar manner. The complainant may have the opportunity for a rebuttal case. I am stressing the word may. Under our rules, a rebuttal case is at the discretion of the chair. It's also a function of how much time you have left and how much time you'd like to allot to closings as compared to putting on a rebuttal case. Following the presentation of all evidence and arguments, the board will adjourn into executive session. Any decision of the board on this complaint is required to be set forth in a written opinion with a written statement of facts that the board relied on. So, let me also remind the parties about one other issue. We have before us another matter, 06-2017, Nunez versus Borrego. That matter is scheduled for an evidentiary hearing next week. That complaint raises not precisely the same, but substantially the same issues that are before us today in your complaint. So at the close of today's hearing, I'm going to be asking counsel for their input, and I'm stressing the word input because we are not bound by what you say, but I'm going to be asking for your input with regard to the timing of our decision given the pendency of the other matter that raises substantially the same issues that will be heard by this board in an evidentiary hearing on the 17th of November. So before we begin, first of all, are there any questions about the manner in which we will be proceeding today by either counsel for the parties?
Mr. Chairman, members of the board, just a few. If you do not rule on the motion to quash and the response today, what's going to happen to that motion and that response?
That's completely up to the parties on how they want to proceed. As I said, we will rule on whatever you ask us to rule on, but it gets taken against your time. I just want to make that very clear. We're not giving you additional time to argue preliminary matters.
And cross-examination, I assume, counts against whichever party is cross-examining?
I have my stopwatch. That is correct.
And so if I request that the board rules on the motion to quash plus the attendant briefs without argument, will that be accepted?
Sure.
That would be my request.
Okay. For the respondent, are there any questions or preliminary matters before we begin?
Good morning, Mr. Chairman, members of the board. With regard to the motion to quash, as I understand it, the individuals who were subpoenaed have appeared. I believe that there are documents that are available, at least from some of the witnesses. I think we do wish that for the board to rule on the motion to quash. I think the arguments have been laid out in both the motion that we filed last week and the response that was filed last night. The other issue, there are two other issues that I wish to raise briefly. One is that Professor Christine Sierra, who was subpoenaed by the complainant, is present. My understanding from speaking with Professor Sierra is that she is scheduled to speak at a conference in El Paso and needs to travel today, and had requested that she be able to leave as quickly as possible. Can everyone hear me? Okay. I've never had trouble with people hearing me. The second issue that we wanted to raise is to make sure that in terms of the timing, that it's as we understand the board's order, the chairman's order, we each have 90 minutes, and that for every minute that one of us is speaking, that time is allocated against the person who's speaking, the party that is presenting.
That's correct.
Okay.
Anything else?
I don't think so. If
All
I
right.
can, just one moment. Okay. No, we're ready. Thank you.
All right. Both parties have requested a ruling on Respondent Keller's omnibus motion to quash or modify subpoenas. I'm not going to read the whole title. That would take up too much of our time. The chair is empowered to make a ruling on all of these. I've read both the respondent's motion and the response, which was received late yesterday and provided to the board before this morning's hearing. The motion will be denied. All of the matters that were raised in the motion are all matters that I believe can be controlled by the board, given that we have the power to limit immaterial, redundant, or repetitive testimony. So all of that will be denied. We will afford full opportunity for cross-examination. Our preference is to hear as much as we can during the time allotted. So the motion will be denied. So up until now, no time has been charged to either party. Each side has 90 minutes beginning now. So for the complainant, Wayne Johnson, the floor is yours.
Mr. Chairman, members of the board, first I want to thank you for your public service. This is quite a public service. The enforcement of ethics with regard to the city campaign is a significant matter. It's a significant matter not just to the candidates, but I think it's a significant matter to the voters and to the citizens. So first of all, I want to thank you for your time. With regard to the complaint, we're here because there has been a clear violation of the rules that are applicable to all of the candidates. Contributions were solicited from private donors after Mr. Keller applied for and received $380,000 in taxpayer money. His campaign went out and solicited from private donors additional private money. That money was received not by the campaign, but by the campaign operatives, the persons working for the campaign, Rio Strategies. That money was then placed into Rio Strategies' bank account. Then the campaign listed on the public reports that these contributions were in-kind contributions for professional services. What the evidence is going to show you, without any doubt, is that this is a subterfuge. This is an end run around your rules, around the rules applicable to everyone, around the rules that require that contributions to candidates who are taking large amounts of taxpayer dollars are prohibited. It was improperly reported. The scheme is something that you'll hear about here today. But how did this get started? Well, it wasn't, I promise you, from either something that we noticed, my client, Mr. Johnson, or me. It was a television report on this plan. I'd like to play that for you right now. Could please add us to the screen then. Let's see. Yeah, there it goes.
In just less than a month, Albuquerque voters will choose a new mayor. But before that happens, our 4 Investigates team is combing through campaign finance reports and looking at who is bankrolling campaigns. Chris Ramirez has some questions for the only publicly financed campaign, Tim Keller's.
And guys, in Albuquerque, mayoral candidates can run their campaigns in one of 2 ways. Method number 1 is the traditional way, where campaigns spend months asking anybody and everybody to donate. 7 out of the 8 mayoral candidates this year have gone that route. Tim Keller is the only candidate going the route of public financing. After a rigorous qualifying process, the city of Albuquerque gave him money, about $365,000 to run his campaign. The caveat: Keller cannot legally raise any more money for himself. But did he find an end around?
To build a better city, we don't just need a mayor. We need a mission, we need a movement.
Tim Keller's campaign so far has been clean. No mudslinging, no controversy.
I'm running for mayor because I believe we can meet these challenges head on.
As the only publicly financed candidate, there's no dark money. He's not beholden to anybody or any company. At least, that's the idea. When we combed through Keller's public finance reports, items stuck out. Dozens of individuals, many high-profile Democrats, have contributed thousands, and the campaign listed the donations as in-kind contributions. For example, former Lieutenant Governor Diane Dennis gave $1,000, and the campaign stated it was for professional services. State Senator Mimi Stewart donated $200 in professional services. A teacher gave an in-kind professional service donation valued at $500. In fact, Keller has collected more than $30,000 in in-kind donations. Okay, let's look at how the city charter defines an in-kind donation. This is directly from the charter, and it reads, a good or service other than money. So what goods or service does Diane Dennis or a state senator or a teacher have to offer?
This is a broad grassroots campaign, and those in-kind contributions go to help support the broad grassroots campaign, from volunteer water and clipboards and stamps to mail to voters, to the communication that we do to voters across the city and communicating Tim's vision.
Jesse Lane Hunt is Keller's campaign manager and a partner at Rio Strategies. Rio Strategies bills itself as a full-service public affairs, strategic communications, and creative service firm. We got a copy of a note that Jesse wrote to somebody. It reads, if you still want to support Tim Keller with an in-kind contribution, like we discussed, you can make a check out to Rio Strategies. Thanks again, and I look forward to hanging out again soon. Jesse, P.S., please write Keller in kind in the memo. People write checks to Rio Strategies. Rio Strategies then uses that money to supplement the campaign.
To in-kind service. Yeah, it's an in-kind service to the campaign.
When we look at the definition of an in-kind contribution, which is stated as a good or service other than money, how do you rationalize accepting money into Rio Strategies?
So any in-kind contribution has a value, and that value is usually ascribed by money. So Tim's fully committed to how we run this campaign as a clean campaign as part of the public finance system. And in that system, it allows for this sort of in-kind contribution, and we are using that to help support Tim's vision and help get him elected.
What are these people in-kinding to you? If you're saying it's not money, it's a good or service, what is that good or service?
They're in-kinding services to the campaign.
So basically what you're saying is they're paying for your time as Tim's campaign manager.
And all of the things that go to help support this broad campaign to help elect him. It's all of the things. It's water, it's clipboards, it's postage, it's office space, it's all of those sorts of things help to support the campaign and the broad, the 1,000 people who are working to help get him elected.
But you're the recipient of the money.
Right, and yes, and that is the in-kind that any individual provides to the campaign, to Tim Keller's campaign.
Some of Keller's opponents have more cash on hand. At the last reporting period, Keller had $227,000. But look at Brian Colon. He had $535,000, and Ricardo Chavez had $373,000. A lot of people might feel like the strategy that you're using is an end round. We know that because Tim is publicly financed, he has a cap, he can no longer fundraise. And so this is your way of finding an end round to fundraise in a different kind of a way. Do you see it that way?
I don't see it that way. We're fully committed, Tim is fully committed to public financing, and this is absolutely part of the way that public financing is set up in the city, and that is the system that we are using.
The truth is, we are in no position to say this new strategy of aiding the campaign's finances is legal or not. Public financing is relatively new to Albuquerque. This is only the third mayoral election cycle where public financing has been available to candidates. If this fundraising method were to be challenged, the city's Board of Ethics and Campaign Practices is the only authority that could investigate and make a determination as to whether all of this checks out or not. Chris Ramirez, 4 Investigates.
And just a reminder, the mayoral election is Tuesday, October 3rd.
Thank you, Wayne. Mr. Keller and his campaign have violated the open and ethical election code by soliciting money from private donors and reporting the donations of money as in-kind contributions for professional services. The open and ethical election code is not ambiguous. In-kind contributions are defined as a good or service other than money. That's it, and I believe, and at this point, let me hand out the exhibit books that we have prepared.
Mr. Rogers, are these books that have already been provided to counsel for the respondent?
Yeah, these are all documents.
Actually, we could get a copy of that so we know what the board has.
So, the Open and Ethical Elections Code is not ambiguous. In-kind contributions are a good or service other than money. I don't think this is difficult. This is what my case is about. Black and white. In-kind contributions is a good or service other than money. What happened in this case was Mr. Keller and his campaign have received over $500,000, over $500,000 in taxpayer money. To supplement that, they have solicited from private sources an additional $38,000 in cash. And then they listed the contributions from private donors who are not providing any professional services, not as cash donations to the campaign, but rather as in-kind donations for professional services. Money means money. There's no ambiguity about that. That's black and white. That's what New Mexico law says. A decision endorsing this chicanery before you would transform the charter rule that no in-kind money donations into exactly the opposite. It's okay for money donations. Endorsing this money grab from private supporters certainly will not avoid the actual appearance of undue influence. One of the important things, one of the important tasks before you, and I've excerpted what I believe to be the important charter provisions, but this is the legislative intent. One of the intents of the open and ethical election code is to diminish the public perception of corruption and strengthen public confidence in the government and election process. What you're going to hear this morning is exactly the opposite through this scheme that's been cooked up. More than 51 persons were solicited. More than 51 persons contributed to, not to the campaign, but to Rio Strategies. More than 51 persons submitted money, and that totals more than $30,000. The total in kind is about $37,000 here. Some of the donations were specific for printing costs and so on. That's a horse of a slightly different color. What you have before you, however, is a gross money grab from persons who, contrary to the public reports, did not provide any professional services. Contrary to the professional reports, the money did not go to the campaign. It went to Rio Strategies. To endorse this would feed the public's growing perception and the cynicism that the rules for public financing and the reporting rules to inform the public are all ignored with impunity. For these reasons, we are going to ask at the end of this that you make sure that there's no benefit from this scheme, that you make sure that an appropriate fine and a public reprimand is issued for this end around that has been designed to attract large dollars, more than $30,000, to this campaign from private sources. That's not what public funding was supposed to be about. Don't let it happen. That's my opening.
Okay. Are there any questions for Mr. Rogers before he sits? I actually have one. You've cited us, and in your papers, to Article 16 in the city charter, the Open and Ethical Elections Code. Is it your position that Article 13, the General Election Code, also applies?
Yes.
Thank you. Any other questions? Thank you.
I would call Mr. Pac-Man as my first witness.
No.
Oh, excuse me. Sorry about that.
That's not like you. Good morning, everyone. My name is David Udias. I, along with Molly Schmidt-Mora, represent Mr. Keller in this matter. Thank you all for being here today, and we do appreciate this opportunity to defend against these allegations. Let me start off by saying that Mr. Keller did not violate any provision of the Open and Ethical Elections Code during any time during his campaign. And we look forward to presenting the evidence to that effect and the legal arguments, because in our view, this is really a legal issue. I'm a little confused by the opening of Mr. Rogers, because their position seems to kind of move and sway at every stage of this proceeding. If you look at the complainant's complaint and in the statement of issues, they create this scenario. This is what their allegations are supported on. They create this scenario, and they actually say it in there that Mr. Keller accepted additional cash contributions to his campaign or to him, and then disguised those cash contributions as in-kind contributions. That's what they said initially. Now I hear Mr. Rogers saying something a little bit differently. But in any event, I can tell you this: you're not going to hear any evidence, none whatsoever, no witness testimony. You're not going to see any documents. You're not going to see any copies of checks that show that Mr. Keller's campaign or Mr. Keller received cash contributions or checks written to Mr. Keller or his campaign on top of the public finance money that he received, because it just did not occur. That is something that has been completely created, and you will see there would be no support for that wild allegation. But now I hear Mr. Rogers saying something a little different, and it's always been our contention that the real thing that was occurring here, what you are going to hear evidence of, is that people who wanted to support Tim Keller, and there are a lot of people who want to support Tim Keller, and that might be one of the reasons why this complaint has been brought. A lot of people want to support Tim Keller, and they would go either to the Keller campaign or to Rio Strategies or to other people and say, how can I help? And they were told, Tim Keller cannot accept cash contributions. He cannot accept money because he's a publicly financed candidate. But what he can do, what you can do if you want to support, is you can pay for services and goods that are going to be donated to him. You can actually write a check to Rio Strategies, which is you're going to hear about them. They're a firm that provides campaign-related services, not just to the Keller campaign, but to a lot of campaigns and a lot of people running for public offices. This is what they do. They provide support for candidates. And these people who wanted to support Tim were told, you can write checks, but you have to make sure that they have in-kind on them, and you can pay for those services, and they will donate those services to Tim Keller. And there is nothing wrong with that. First of all, Mr. Rogers is right. The code says goods and services. That includes professional services. You're going to hear some testimony about that from people who actually know public finance law. And you can read the cases that we cited to in our brief and look at the codes in California and others who have gone a little step further and described further what in-kind contributions are. So the correct question then is whether that scenario where a supporter actually goes and pays a third-party vendor to provide a service or a good to a candidate, whether or not that's an in-kind contribution. And you're going to find that it is. The complainant cites to absolutely no cases, nothing in their legal briefs, no legal authority. No, they don't cite to another code from another jurisdiction that describes this or says it's unlawful. They can't do it because it doesn't exist. Now, in our legal brief, we provided you some examples, some cases from Washington, some cases from Texas, some cases from California, and those have to do with, really what have to do with, when a donor pays a third party to provide a service or a good, does that have to be reported? And they all say yes. They all come down on the side of Tim Keller in this case. They all say that can occur so long as it is reported as an in-kind contribution and it doesn't exceed the cap on that. And there's no question here that the in-kind contributions that were provided to the Keller campaign did not exceed the cap. There's just no question because they were very careful about making sure that it did not. And they kept an accurate and transparent process available to the public. Nobody discovered anything here. There was no moment of aha, digging through documents and pulling them out. And Mr. Rogers just admitted that. They didn't discover this. And neither did Chris Ramirez from 4KOB. He didn't discover this. He didn't go out and find some treasure trove that was hidden by the Keller campaign. This was all publicly reported, correctly and accurately, and as provided by the code. And we point this out in our brief. Section 6F of the code actually contemplates this situation, where somebody pays a third party to provide a service, or an employee is providing a service to a campaign. If somebody's paying for that, that person who's paying for it is providing an in-kind contribution. That's what the code contemplates, this very scenario. And that's what the other jurisdictions have said as well. So when we look at this through the correct factual lens and the correct legal perspective, it is clear that this is completely okay in the code. Not only is this okay, not only is this something that the code contemplates and the code requires that the reporting be done, which was in this case, but it makes sense. This kind of system makes sense, and actually it's the best way to do it, if you think about it, and you're going to hear people talk about this. Because there's no doubt that candidates can receive in-kind donations of goods and services. If you have people just donating goods on their own or services on their good, how does the campaign know, or how do they know that the campaign actually needs these things? How do they know? They would have no idea. Campaigns will be flooded with services they don't need or goods they don't need. In this case, the third-party vendor makes that determination. That's part of the services they're providing. They're making sure that those goods and services, copying services, professional services, these are all things that the campaign actually needs and could use. So it's a very efficient process. Second, if people were providing in-kind donations to a campaign, the issue then becomes are they being properly valued? Because there's a requirement that those in-kind contributions do not exceed a certain amount. I think in this case it was $38,000. So how do you value that? It then the burden falls on the candidate to value the in-kind. And then there's going to be challenges from their opponents saying, well, you didn't value it correctly. You undervalued it, so you could get a lot of goods, a lot of services. There's all these pitfalls. This system, making sure that there are professionals who provide campaign-related services, who make determinations as to what that money can be used on, makes it more efficient, makes it more accurate, and makes it more transparent. And that's what the code is about, making it transparent. What Mr. Rogers and Mr. Johnson are asking you to do is to rewrite the code, to rewrite it or put language in it that says money can never be involved. If it's an in-kind, money can never be involved. And that is just simply absurd. There is always going to be money involved. For people who donate signs to a campaign, for instance, if I want to go and donate signs to Tim Keller's campaign, somewhere along the line, I'm going to pay money for that. The only scenario I can think of is somebody chopping down a tree, making the paper, making their own ink, and then providing it. And even that, I think there's going to be some money involved. There's going to be some cost of material. So the issue of whether there's money involved, that's not the focus here. If you look at the code, the focus is on what the candidate receives. And you're going to hear testimony about that. Again, from people who are very, very knowledgeable, who have studied public finance systems all across the country. That's the focus. Not whether somewhere along the line money is exchanged, but what is received by the candidate. And in this case, Mr. Keller did not receive any additional cash or money from anyone at any point in time. What he received were the goods and services from Real Strategies that were donated by people who wanted to support his campaign, and that is perfectly legal under the code. No matter how bad Chris Ramirez makes it sound, because he's an investigative reporter and he wants to make a story, and no matter how bad Mr. Rogers and Mr. Johnson makes it sound. So after you hear the evidence, you read the code, you review the briefs, you hear from the witnesses, we hope that you can come to the conclusion that this was approved by the code. It is something that is not prohibited by the code, and we ask that you dismiss this case in its entirety. Thank you.
Before you sit down, are there any questions from the board? I'm going to ask you the same question I asked Mr. Rogers. Is it the respondent's position that Article 13 of the Charter governing the General Election Code applies to this case?
I feel like that's a trick question because I haven't gone back to look at Article 13. I will say this, Chair. Chairman, what I understand is in the code, in other parts of the code that don't relate to public financing, for instance, there are other definitions of in-kind contributions and services I'll let the witness who's going to talk about that point that out. But it's my understanding that the in-kind, the definition of in-kind is consistent with our position and consistent throughout the code. So I would say that if there's definitions regarding in-kind services or contributions or something that might relate to this case, then certainly applies because we have to read the code as a whole.
Okay, thank you. Any other questions? All right.
Thank you.
Thank you. Mr. Rogers, the floor is yours.
I would call Mr. Packman to the stand.
And let me ask the city clerk for a quick question. Where are we putting the witness? Okay. And while we're getting organized, let me tell council that after opening statements, the complainant has 75 minutes remaining and the respondent has 80 minutes remaining. And by the way, Mr. Rogers, none of this time is getting charged to you while we get set up here.
Thank you.
All right, thanks very much. If I can ask the witness to raise his right hand. Do you swear the testimony you're about to give will be the whole truth? Yes. Okay, thank you very much. Is the green light on for your microphone? Okay. Mr. Rogers?
Mr. Peckman, did you bring documents responsive to the subpoena Dukas Takem?
Yes.
May I have those? Did you supply all of the documents requested in the subpoena?
Yes.
You supplied all documents concerning in-kind contributions considered, solicited, or received, right?
Yes.
You provide.
Excuse me, can I ask the witness to speak up just a little bit into the microphone? Thanks so much.
You supplied Real Strategies invoices 40 through 48?
I'm sorry. I gave all documents that were responsive after confirming with the attorney.
So in this set of documents will be invoices 40 to 48?
Invoice 46 was responsive. The other invoices were not related to the Keller campaign.
So you have not provided all of the documents in the subpoena, is that correct?
After confirming with the attorney, I provided all the documents that were responsive.
So you and your attorney decided what was responsive? So the subpoena says provide Real Strategies invoices 40 to 48. You decided that's not responsive?
Those are not documents related to the Keller campaign. There are other clients.
What other documents have you not provided responsive to the subpoena?
I'm sorry, I want to object to the questioning regarding the invoices. Chairman, as you know, Mr. Rogers sent us a communication a couple of days ago and narrowed the scope of the subpoena to just those invoices that had to do with the Keller campaign. So to the extent that Mr. Packman is providing that, that is completely in compliance with the subpoena and the statements made by Mr. Rogers regarding the narrowing of the subpoena.
Well, let me make one point very clear. I unfortunately got put on an email loop for communications between counsel, and after receiving roughly 10 to 15 emails per hour, I specifically asked all counsel to delete me from their email lists. I did not read any of those emails. I consider them all to be improper ex parte communications. I'm not aware of any agreement between counsel. That's between the two of you. Communicating with me outside of the bounds of this hearing simply is not proper. So with that in mind, you can have an objection, and if that's what I'll rule on. But if it has to do with an agreement to which I supposedly was a party to, that simply is not correct.
And it's not. It has nothing to do with any communication that you might have been a party to, Mr. Chairman. It has to do with the emails that were sent to us from Mr. Rogers narrowing the subpoena in response to our motion to quash. So when we asked you earlier to rule on the motion to quash, we are considering that to be on the narrowed issues that Mr. Rogers provided to us. And I don't know if you want to ask Mr. Rogers about whether he agreed to narrow the subpoena to the issues related to the Keller campaign, or if he's keeping it as broad as what he initially provided.
What I would like to ask is this time coming out of my time?
Gentlemen, you're both extremely experienced attorneys. You know the way clocks work. Every time you speak, it's your time. Every time the other side speaks, it's their time. Here is what I'm going to rule. As I told you at the very beginning, we are not operating under the rules of evidence. The constraint that is on both sides under our rules is that I am permitted to not allow irrelevant, immaterial, or unduly repetitious evidence. Mr. Rogers, I'm going to give you a little bit of leeway to explore this with this witness a little further. Again, this is your time, but I will impose the restraint that this is becoming unduly repetitious, and I will ask you to move along. But I will give you a little leeway to move forward with this line of questioning.
Mr. Chair, if I may just make one final comment, and I don't mean to interrupt any of the examination. The reason that I raised the objection to the subpoena issue is because, as you recall, at the last hearing that we had for a different client, the board asked the city attorney to then enforce the subpoena through a district court action. And I'm just trying to make the record here to make clear that there were agreements between the parties and the council regarding the narrowing of the subpoena, and I just don't want that to be an issue later for Mr. Packman or his counsel. Thank you.
So noted. Mr. Rogers, the floor is yours.
Yep. So the record's clear. The proposal was a proposal that was not accepted. No documents were supplied. No narrowing was agreed upon. So let me proceed. So who's your attorney, Mr. Packman?
Mr. Harrigan.
And what firm is he with?
Associated Gems.
And so invoices 40 through 48 are not in the documents here because you and your attorney decided they're not relevant, correct?
They are not in the documents.
What other documents are not relevant that you decided not to produce, called for in the subpoena duca stacum, sir?
I think we reproduced all the relevant responsive documents.
Okay. So in your documents will be any correspondence, emails, or documents received concerning any approval, precedent, advisory opinion, or justification for reporting of the donations as in-kind donations for professional services. Is that correct?
Yes.
It'll include any correspondence, emails, documents, or any type or form concerning, evidencing, detailing, establishing, or explaining the professional services referenced in the reports filed by the Keller campaign for all of the in-kind donations, right?
Yes.
Are your copies of the in-kind checks in this set of documents?
No.
And why not?
I believe they were either produced elsewhere or not responsive to specific.
Who produced them elsewhere?
I believe they would be offered.
Did every last person who sent you a check, did they write in-kind on the check?
To my recollection, I believe so.
Did you look at all 51?
I believe so.
So you looked at all 51 checks for in-kind services, and each one printed in-kind or Keller in-kind on them, right?
I believe so.
And those checks were deposited in Rio Strategies bank account, right?
Yes.
And what happened then? Then at some point you prepared a document and you sent it to Mr. Keller, the campaign, right? Invoice 46?
Invoice 46 reflects goods and services provided to the campaign.
And that was, for what reason was invoice 46 prepared?
Individuals were paying Rio Strategies for in-kind goods and services to be given to the campaign.
And invoice 46 was sent to the Keller campaign, correct? And if you look in your notebook, invoice 46 is Exhibit C.
Mr. Rogers, I'm sorry, our exhibits have numbers, not letters.
Let me then use the with some help. Is there a button here I need to press? Oh, it's not. Okay. This is invoice 46 that you sent.
Again, Mr. I'm sorry, which exhibit is this in our notebook?
This is the respondents. I don't think it's in your notebook. This is respondents Exhibit C.
Mr. Chairman, we have notebooks with our exhibits. If you'd like us to pass them out so you can see what he's referring to.
To make it clear. Can you blow that up?
Mr. Chairman, would you like to pass out the exhibits to the respondents? Actually,
I think we're good for right now. We'll find a better spot to swap notebooks.
Okay. Exhibit C is a document that you prepared, right, sir?
Which document are you referring to?
Exhibit C, invoice 46.
Is this the document you're referring to?
Yes, Exhibit C, invoice 46, right?
Yes.
When did you prepare that? It's dated August 1, 2017. Is that the date it was prepared?
It was the date the invoice was began.
What do you mean began?
Invoices are a work in process, often beginning and built, draft forms flushed out as work is continued and performed and delivered on time.
In Mr. Keller's production of documents, 3 pages, there is no copy of invoice 46. Was invoice 46 actually sent to the Keller campaign?
I believe so.
When was it sent?
Approximately September.
September when?
I don't specifically recall the date.
For what purpose was this prepared, sir?
In regular course of preparing for campaign reports and delivering statements about the work that was being done.
Has your bank statements, Real Strategies, ever been provided to Mr. Keller for his review?
No.
Has he ever asked to review any Real Strategies bank statement?
Not to my knowledge.
Has anyone ever looked to determine what checks have been received by Real Strategies to benefit Mr. Keller's campaign?
Yes, we had a full tracking system in place.
You, sir, have done that?
Yes, we had trackers.
Who from the Keller campaign has reviewed your bank statements to determine what checks have been received by persons contributing to the Keller campaign?
Can you rephrase the question, please?
Yes. No one from the Keller campaign has ever reviewed your bank statements to determine who actually has contributed to the Keller campaign with Real Strategies' name on the check, correct?
That is correct.
What happens to a check at Real Strategies if it doesn't say Keller in kind, if it just says Real Strategies?
Can you be more specific?
Yes. The instructions from Ms. Hunt, and if you turn to Exhibit 5, sir. That's it. These were standard instructions that were given to potential donors, correct? Okay. Who's the we? It says, if you still want to support Tim Keller with an in-kind contribution, as we discussed. Who's the we in this?
I don't specifically know.
Pardon?
This appears to be a standard thank you note that was sent to people. I don't specifically know who this was.
So you've never made any inquiry as to who provided this document to Channel 4?
We sent thank you notes to everyone.
And my question is, you've never made any inquiry as to who sent this note from your office to Channel 4?
No.
You don't know who that is?
I do not know who the specific letter was sent to.
And so this would reflect a standard solicitation and a standard thank you process for the donations that your office solicited, correct?
The in-kind contributions allow up to the limit. We're absolutely part of the campaign. We were running, and people who were told that they were absolutely in no way able to give cash or check donations directly to the campaign, that they were able to make in-kind contributions of goods and services to the campaign to be allowable.
Other than you and Ms. Hunt, did anybody solicit donations in this fashion reflected by Exhibit 5?
Yes.
Who?
Mr. Keller.
And do you know which donors he solicited? And
Not specifically.
so the money just comes in, and it's deposited into your account.
There is a rigorous tracking system.
And has that rigorous tracking system been ever audited by the state auditor, for example?
I'm sorry, can you clarify that?
Has this rigorous system that you internally employ ever been reviewed by anybody outside of your company?
I mean, for reporting purposes, we review our reports with Mr. Keller.
So Mr. Keller is familiar with what exactly? Has he seen the checks?
Many of them.
How did that process work? You'd open checks in front of him and check off the donors that you had solicited?
This was a process that, as the reports show, went on for months, and solicitations and collections occurred in a variety of ways, all following the code that is in-kind goods and services for real strategies not to be.
Did Mr. Keller receive any checks made out to Real Strategies and review them to determine who had sent them or if they were being properly deposited into your account? So if your company received more than the checks that are reported by the Keller campaign, the only persons that would know that would be you and your company, correct?
Correct.
So there'd be nothing to stop you from receiving lots more donations, to, as it says here, to help support Tim Keller and depositing those into your account, right?
That is totally against the law.
And what would stop you under this process, other than your conception that it's against the law?
Both the auditor as well as myself and Real Strategies uphold the highest levels of transparency and accountability and take that really seriously.
Has the auditor audited you in any fashion to determine that all of the checks submitted to your company were deposited into your account and then accounted for with regard to the debts of the Keller campaign to you?
Can you repeat that?
Who is actually checking to see that you haven't collected lots of money, more than what has been stated in the documents filed by the Keller campaign?
We have a rigorous system. Sticking to the cap is extremely important. And that's why this system was in place, because it's completely transparent, it's accountable, it assigns specific values, and we absolutely did not and would not go over the cap.
When you say it's transparent, are the documents to establish it's transparent in the documents that you provided today?
Can you be specific?
Yeah. Do you provide your bank statements of all of the checks that Real Strategies has received?
No.
Do you supply all of the expenditures that Real Strategies has received?
No.
So in order for this board or the public or the voters to believe that this is all transparent, you'd have to supply those records to show that you, either with or without Mr. Keller's knowledge, are collecting only the checks that his campaign is reporting, correct?
I'm sorry, can you rephrase that?
Yes. In order to be transparent, you would have to provide your bank statements to show that you are not collecting checks that are not being reported by the Keller campaign, right?
I don't believe that's the only way to demonstrate transparency.
Have you, with regard to your company's receipt of checks, in what way is it transparent if you haven't supplied the documents to establish that it's transparent, sir?
We are a local small business, a vendor to the campaign. We take our own internal processes very seriously. We take the reporting we do for clients extremely seriously, including reviewing all the reports that go out. As I mentioned, this is not only for Mr. Keller, but for ourselves, an extremely important part of the process.
So if the board was to enforce a subpoena and require that the checks be provided, it's your testimony under oath that all of the 51 checks that have been listed for professional services would say in kind on those checks. Is that your testimony, sir?
We would be happy to provide any additional documents if they were responsible.
So you'll provide those documents or not?
We'd be happy to provide any additional documents if they were responsible to your request.
Is that a trick answer? Are you going to supply the documents that will show those checks were labeled in kind, or are you not going to supply those documents?
If you were requesting to, yes.
I'm requesting. Will you do that?
I'm not sure I understand the question. I'm not an attorney. I'm not sure what
Right,
you're
right.
referring to.
In the history of politics and political operatives, is there any sort of suggestion that politicians or political operatives have taken money that they're not entitled to, sir?
In the history of politics, yes.
Okay. So let's just say you made a mistake, that someone submitted a check to Real Strategies that they intended to benefit the Keller campaign, and you didn't get it right. The only way to know that would be to look at your bank statements and the records that would establish that you have properly told the Keller campaign about all of these checks that you received, right?
We would not have accepted or deposited or accounted for those checks in that way if they were not specifically ascribed to the Keller campaign.
How would you know that if it's made out to Real Strategies and it doesn't say in kind for Keller campaign? How would you know?
We would not have accepted that for this purpose.
And the way we'd know that is if you had complied with the subpoena and provided these documents, correct?
We would not have accepted any checks.
Okay. Well, I'm going to reserve my request that the subpoena be enforced to the end of the proceeding, but I do not want it waived or otherwise construed as something that's unimportant. Mr. Pac-Man, do you attend the training sessions for candidates and treasurers?
I do not believe I was in all of them. I was in many of them.
So you're familiar with the rules?
I have read the rules.
Pardon?
I have read the rules.
Okay. So one of the rules is that all contributions of money received for the benefit of the candidate's campaign shall be deposited in the campaign's bank account, right?
Money to the campaign.
All contributions of monies received for the benefit of the candidate's campaign or the Measure Finance Committee shall be deposited in that campaign. You're familiar with that obligation, right?
Yes.
And here, when people send checks to Real Strategies, as it says right here in Ms. Hunt's note, if you want to help Tim, if you want to help the Tim Keller campaign, send us a check. You're depositing those monies in an account separate from the campaign account, right?
Those monies were not for the campaign. They paid for Real Strategy services and were in-kind donations to the campaign.
Were they for the benefit of Mr. Keller?
They were in-kind services paid to Real Strategies for our services, just as if someone had paid for signs or paid for other items. They were services that were in-kind contributions to the campaign. At no time did the campaign take cash or checks or any other money following the seed money period.
How would you know? You're running Real Strategies. You don't know what Liz McMaster or the campaign was doing with regard to money? Let me strike that. Am I reading this correctly? All contributions of money received for the benefit of the candidate's campaign shall be deposited in that account, and all disbursements shall be made from that account.
Excuse me one second. Mr. Urias?
I'm going to object, Chairman. I know that you don't necessarily like the objections, but these are legal arguments from a part of the finance law that have nothing to do with in-kind contributions.
Mr. Urias,
Oh, sorry.
I'm sorry. Can you ask everyone to stand to
Yes, excuse me one second. The city clerk has asked that everyone who stands to speak please come to a microphone, because otherwise the entire room can't hear. And the recording won't pick it up.
Chairman,
so sorry to interrupt.
Chairman, the objection was to the fact that this is a question. These are questions really pertaining to the legal arguments and the public finance laws. Mr. Packman is not a lawyer. He's got a lawyer here, but he's not a lawyer. The sections that are being cited to have nothing to do with in-kind contributions. They have to do with money coming into the campaign, like the public finance money itself coming into the campaign. This is confusing for the witness. This is prejudicial to the respondent because it seems to be basing a record or creating a record that doesn't make any sense because this is not relevant to the issues that are before the board. So we would object to the line of questioning to the extent that Mr. Packman is not a lawyer and to the extent that this has nothing to do with in-kind contributions. And I believe Mr. Packman has already answered the question at least 4 times regarding what he believes that provision to be stating.
All right, I'm not going to call for a response. Again, my powers, great as they may be, are limited to irrelevant, immaterial, or unduly repetitious evidence. Is it one of those 3 things, Mr. Reyes? Because otherwise I'd like to move along.
It's all 3 of those things, Mr. Chairman, all 3 of those things. It's immaterial, it's repetitious. He's asked the same question at least 6 or 7 times, and Mr. Packman has answered the question, I think correctly, that this pertains to money going to the Keller campaign and not to real strategies for in-kind contributions.
Well, I'll overrule the objection, but as a gentle reminder, so far we are into 21 minutes with this witness, Mr. Rogers. Again, the floor is yours. You can spend your time as you wish, but with that objection in mind, I'll ask you to continue.
You don't have access to the Keller campaign bank account, do you?
I do.
You have access to the Keller campaign bank account?
Yes, I am a signer on that account.
And that's
Excuse me one second. Is your microphone on?
It's on. Is it close enough? Is this one, I guess I shouldn't split the difference here.
Yeah.
Okay. Real Strategies has a separate bank account for in-kind checks, correct?
I'm sorry, can you clarify that?
You received in-kind checks responsive to your solicitation, and you deposited those into a Real Strategies bank account, didn't you?
That's correct, because they were payments to Rio Strategies, not money to the campaign.
Right. Let's go back to Exhibit C just for a minute, the invoice that you prepared. So the purpose of this invoice, Mr. Packman, was to zero out the in-kind contributions that you'd received, right?
Yes.
You never told people who submitted a check which has been labeled for professional services that actually it would be used for CRM software or postage or database or photography, right?
That's incorrect. We did.
So you told people that, I might have misunderstood the pitch from Ms. Hunt there, the document that we looked at there. There was no indication there that that in-kind check would be used for anything specific, was there?
In conversations we had with people who were interested in helping the campaign, we absolutely, excuse me, relayed the types of things that their donations would be used for to support the campaign.
Do you have any single document that supports that testimony, sir, where someone wrote a note and said, we're going to take your $1,000 and we're going to use it for postage or digital advertising or software or photography? Is there any written document, sir, to support that testimony about conversations with other people?
Potentially on social media, but not in what I provided you.
Did you supply your social media comments in response to the subpoena duces tecum for such documents?
My own personal comments, no. They would have been, as I mentioned, this was not a secret. There was no nefarious plan here. This was something the campaign was talking to people about because it's part of the public finance law.
My question was, if it's not a secret, why didn't you produce the documents pursuant to the subpoena ducis tecum that would establish exactly what you have said?
As I mentioned, I produced the documents responsive based on conversations I had with an attorney.
So you and the attorney decided that those comments, those written comments of yours or anyone that you're aware of would not be provided because you determined they were not relevant, correct?
I think Mr. Rogers knows the rules about attorney-client privilege. I think he's asking him exactly what him and his lawyer talked about, and I think, and I'm not sure where Mr. Harrigan is, but this is obviously attorney-client privilege, and I'm not really comfortable with him answering those questions. So to the extent that we can, we would ask that Mr. Packman not answer that question.
This is what I'm going to suggest. Again, the rules of evidence don't specifically apply. Mr. Rogers, I think you've made your point on this, so I'm going to suggest that you move along.
One last question about invoice 46. On this invoice that you prepared, and this was a document that was supplied to the board on September 15th. This was attached to the first response. It's in your evidence book, the September 15th response. This was supplied for the purpose of indicating that all of these in-kind contributions had been used for these items listed, correct?
Yes, this is an accounting of the in-kind services that were paid to Rio and given to the campaign.
And there is no listing here whatsoever of payments to your firm for professional services, correct?
The document lists all of the items that were used.
And so none of the money was used to pay for professional services?
Well, the professional service was helping the campaign decide which of these things and when they were needed and how to deploy them.
Well, if all of the money was used for these items here, there's no money left to pay you to decide how to allocate the money, correct?
I believe it's all sort of one and the same.
Sir, agree with me. Or tell me what I'm missing, because my eyesight may not be that well. This document accounts for all of the in-kind contributions, and there is no listing for professional services for your firm or for anyone, correct?
Part of the cost of all of these are acquiring, deploying, and dealing with all of these as well.
So is there additional amounts that are going to be listed or have accrued on top of this accounting for all of the dollars?
As the publicly available reports show, Rio Strategies has been paid for a variety of the services and items and goods throughout the campaign.
And on this accounting, sir, and I'll move on. There's nothing here to indicate payment for personal services, correct?
As I've said, the researching, deploying, acquiring all of these things is part and parcel of all of those services as well.
Even though it's not listed?
Yes.
Okay. So the report which says the in-kind donation was for personal services, there's no document to reflect that anywhere in your records, correct?
I disagree with that characterization.
Where's the document?
And as I just mentioned.
So the document reflecting that those checks, which were listed as paying for professional services, are supported and established by Exhibit C, Invoice 46, which does not list anything for professional services. Is that correct?
This document accounts for all of the services that were in-kinded by individuals to the Tim Keller campaign.
Thank you.
Cross-examination for this witness.
Yes, thank you, Mr. Chairman. Good morning, Mr. Packman.
Good morning.
Mr. Packman, you are a partner of Rio Strategies, is that correct?
Yes.
Okay, and that's Rio Strategies, LLC?
Yes.
All right. And what else do you do other than the work that you do with Rio Strategies?
I have a number of community positions. I'm the chair of the Bernalillo County Code of Conduct Review Board, which is the comparable board to this board at the county level. I've served in that position since 2012. I am also the vice president of the Albuquerque Preschool Cooperative, where one of my sons attends.
Okay. And then you do your work with Real Strategies as well?
That's correct.
All right. And how long has Real Strategies been in existence?
We opened under a different name, Full Arsenal Strategies, in 2015, but other than a name change since 2015.
So Real Strategies is a company that has existed since 2015?
Yes.
And when were you retained or hired by the Keller campaign to provide campaign-related services?
At the beginning of this year.
About 2 years after Real Strategies came into existence?
Yes.
And is Tim Keller the only client that you have?
No.
What else? Who else does Real Strategies, or what kind of offices do they provide services for? Or what kind of campaigns, I should say?
Sure. We've worked with dozens of political candidates, advocacy organizations, labor unions, school districts, all sorts of folks in New Mexico and outside of New Mexico.
Let me ask you a little bit about the work that you've done for the Keller campaign. And I think we've talked a little bit about it, and I want to go back to that invoice that Mr. Rogers was talking so much about. With regard to the goods that are provided there or noted there and the amount of money, was the purpose of those invoices to provide the Keller campaign a clear indication of what money was being spent on for the services and goods that were being donated to the campaign?
Yes.
And I think you answered the question, but I want to make it clear. Your testimony is that money and the accounting of that money and the reporting of that money included both the goods themselves and the services associated with determining what goods would be provided to the campaign. Is that right?
That's correct.
All right. And so you were able to give Mr. Keller a very clear accounting of how much money was being spent on these goods and services that were being donated to him?
Yes.
And was the purpose of that to make sure that Mr. Keller's campaign kept within the confines of the law and kept the in-kind contributions to less than $38,000?
Absolutely.
Did you at any time ever try to hide any of this information, either in public finance reports or invoices that you provided to Mr. Keller? Was there ever an attempt by Real Strategies to not disclose information to the Keller campaign?
No.
You've obviously you've been here this morning. We appreciate that. Thank you for coming. I want to ask you, you've sat through all the argument, I guess, made during the opening statement. You understand the position here being that somehow, and to be quite frank, I'm not really sure exactly what the position is, but somehow that it was Tim Keller's campaign was receiving money or cash contributions on top of the money they received through the public finance system. You understand that to be one of the allegations?
Yes.
Have you ever seen any document, whether in your work or elsewhere, even in this case, which shows or implies or indicates that Mr. Keller or his campaign ever received money contributions to his campaign or to Tim Keller?
Following the appropriate seed money period, absolutely not. In fact, many people, to this day, we continue to tell people who would like to make contributions to the campaign that we can't. That Tim is a publicly financed candidate. He cannot accept contributions. There is no in-kind contribution allowed in the runoff election. You know, we had essentially hit the cap in the previous election. And that's a conversation that happens regularly. At no time did Tim's campaign take any cash following that seed money period.
All right. At any time when people wrote checks to Real Strategies, was there ever a time where you cashed those checks and then provided the cash to Mr. Keller's campaign or Mr. Keller?
Absolutely not.
Was there ever a time that you signed off on the checks and wrote them, you know, kind of on the back and signed them off to the Tim Keller campaign and passed those checks themselves directly to Tim Keller?
No.
I think I understood your testimony that you took those checks from donors who wanted to provide an in-kind donation, and you used that money in order to buy the goods and to provide the services that would get those goods to Mr. Keller. Is that right?
Yes.
Did you ever, I mean, we're talking about the cap, the $38,000 cap on the in-kind donations. Was there ever a time where you were returning checks to people after you had reached the cap?
I believe so, yes.
Okay. Has there ever been an allegation from either Mr. Rogers or Mr. Johnson or anybody else that Rio Strategies allowed more than $38,000 in in-kind contributions to come in?
Not that I'm aware of.
Have you ever heard, and this is an interesting line of questioning that Mr. Rogers had for you, before today, had you ever heard the allegation or even the implication that Rio Strategies might be accepting tons of checks and just keeping the money for themselves rather than using them for Tim Keller's in-kind contributions?
No.
Right. No one's ever said that to you before?
No.
All right. And you've never seen any evidence of that in the form of a document or a letter or even a warning or anything from anyone?
Absolutely not. As I mentioned, we take these processes exceptionally seriously.
We were talking about the checks that were provided to Rio Strategies. I think you said you believe, you're not sure, but you believe all of them might have said in-kind on there on the memo line. Why were people told to put in-kind on the checks?
So we could keep an accurate accounting of the services to be provided to the Keller campaign.
Okay. And did that system work?
Yes.
Do you think the system that where somebody is paying a third-party vendor, you, Rio Strategies, to then contribute goods and services, or paying for those goods and services, do you think that works in the public finance system? I know you've had some experience with that in your experiences with the Board of Ethics for the county and other things that you've done. Why is that system, or do you think that system is a good system and a transparent system?
Absolutely. I think it's frankly, the most accountable system and the most accurate system. As was previously mentioned, in-kind contributions could come in lots of different forms, but knowing that there's that cap and that you want to have the best accountability and reporting of those contributions, being able to assign specific value to the services that were being provided, I think is really important. It just keeps it really clean.
I want to ask you, I think Mr. Rogers has already asked you about the invoice and the campaign finance reports, which were, to your knowledge, all accurate and correct.
Yes.
I want to ask you about I think it is Exhibit F to Keller's. I'm sorry, no, those are the checks. Let me find the correct exhibit here. You have that notebook in front of you, the respondent's notebook? Okay. I think this is Exhibit E. This is an email between a campaign auditor and Diane Gibson.
I'm not sure I have that. I have the Johnson exhibit book.
All right, let me get you a copy of that. And actually, do we pass them out?
Mr. Uris, we don't have a copy of your notebooks.
We'll pass out the notebooks now since we're getting to that point.
Thank you.
Do you have that notebook in front of you?
Yes.
Mr. Franklin? Looking at Exhibit E, the email, can you tell us a little bit about where that came from and whether you obtained that and what the significance of that email was to you?
Yes, it's an email that is a communication between City Councilor Diane Gibson and the City Auditor, Mr. Grisham, about in-kind contributions and a question that the City Councilor asked regarding paying a third-party vendor to purchase signs for the campaign, and the city auditor agrees that that kind of system is within the boundaries of the code.
And that was the system you're talking about is a donor being solicited by a candidate for in-kind contributions, and those checks then being sent to a third-party vendor who provides that in-kind contribution.
That's correct.
Okay. And in the email, you see there it says that the candidate in question here says that she had talked to Helen Elliott, who agreed that that this system was within the laws and regulations. Do you know who Ms. Helen Elliott is?
Also a city auditor.
Okay, so there was you had an email from a city auditor, and then you're not, and I want to ask you this, you're not saying that you relied on this before you began working for the Keller campaign, correct?
No.
Okay. When did you get this, and why did you get this?
A couple months ago, in conversations with Councilor Gibson, she mentioned that this letter existed.
Was this after the ethics complaint was filed by Mr. Johnson?
Probably.
Okay. And did you obtain this information because you wanted to go out and see whether or not this system had been approved of before, or at least there was some indication that it was legal?
Yes.
Why hadn't you asked for? Well, actually, Mr. Rogers asked you whether or not you had requested an advisory opinion before accepting these in-kind contributions, but you're not the campaign, correct?
No.
Okay. And did you have any question when you began this process as to whether it was valid within the code?
No, the code seems fairly straightforward.
And so these emails just kind of confirmed your understanding of the way that third-party vendors being paid for services or goods that had to be reported as in-kind contributions.
Yes.
Thank you, Mr. Packman. We have no further questions.
Any further questions of this witness?
Yes. Mr. Chairman, briefly. Mr. Packman, do you remember the email you received, or excuse me, the email that you sent to Jesse Hunt on September 16th, 2017? This is in the documents that you supplied me. Do you remember that?
I'm sorry, I did not bring my own copy. If I could reference it, please.
Let me just read this to you and see if it refreshes your memory. This was September 16th. This was after the ethics complaint was filed, right? This was after the KLB story on September 7th, right? So on September 16th, you emailed Jesse Hunt, and you say, there's a bullet point here, campaign is in full compliance, attacks are from the GOP party and GOP opponents. And the last one is all in-kind used for campaign materials, paper envelopes, databases, printing, social media ads. You see that?
Yes.
Is that accurate, what you told Ms. Hunt on September 16th, 2016?
Yes.
And so you told Ms. Hunt nothing about professional services, correct?
No.
Okay. And you didn't consider the KLB story an attack?
No.
On September 12th, Mr. Keller emails you and he says, can you ask Martin to at least say in-kind donations are allowed and capped at $38K? He printed all of Wayne's quotes and they were all attacks on us. You remember that email?
Yes.
Do you know why Mr. Keller did not supply that in response to his subpoena asking for his documents about in-kind donations?
I wouldn't be able to speak to that.
You remember the email from Dan McKay on September 9th, 2017, when you were trying to get Mr. McKay to suggest that these in-kind donations were what Barry was doing in 2009. Do you remember what Mr. McKay told you?
I remember the email. I don't specifically remember the response.
Let me see if I can refresh your memory. It said, I don't think it's clear from Barry's 2009 reports that his campaign was soliciting cash contributions to pay for in-kind services. You remember that from Dan McKay?
Yes.
You've produced no documents that show that the Barry campaign was soliciting in-kind donations for professional services, right?
I did not. Those their reports are publicly available on the city's website.
And the attorneys for Mr. Keller have produced nothing to show that the Berry campaign solicited private donors for in-kind contributions and listed those as for professional services, right?
I can't speak to their documents.
You don't know of any, right?
I don't know what they produced.
You remember the September 9 email from Ms. Denish?
Yes.
Well, would you tell the board what Ms. Denish wanted to know on September 9th? That is 2 days after the KOB report and 1 day after the ethics complaint was filed. Do you remember what she asked you?
I don't remember the specific question, but there were a lot of folks wanted to get more information about what was going on, and we were happy to provide that.
Can you be any more specific about what Ms. Denish wanted to know?
I don't specifically recall.
Let me read this and see if it refreshes your memory. This is to you on September 9. Every in-kind donor needs this. Now, I have had 3 emails just this morning. Sadly, most of this problem is at your feet, not ours. You remember that?
Yes.
And so her concern, obviously, was this was a problem for the Keller campaign and not something that the ours had just thought up out of thin air, right?
That is what the email says.
Do you have any conversation with her that suggested otherwise, that this wasn't your problem?
Not that I specifically recall.
You were asked by Channel 4 on September 10th if Mr. Keller, in light of the in-kind issues, was uncomfortable, and if he's elected mayor, would he work with the city council to clarify the open and ethical elections code on this point? And if so, what kind of clarification would he support? You remember that?
Yes.
And so this perfectly lawful, perfectly fine scheme that was put together, what did Mr. Keller have you tell Channel 4 that he was going to do if he was elected mayor?
Throughout the campaign, Mr. Keller has been absolutely clear that this is not a perfect system, but it is the best system to ensure that big money is out of politics, that this is the best way for him to run a campaign, and that there are changes that are needed, and he will absolutely work for those as mayor.
So he's going to change this particular scheme, correct or not correct?
I completely disagree with your notion that this is a scheme, and I wouldn't be able to speak directly to provisions that he would or would not plan to change.
And getting big money out of politics, that wouldn't include the $5,000 check that was paid to Rio Strategies from Mr. Cochran. That's not big money, right?
Those are in-kind donations of services to the campaign, as is completely allowable under the code.
But it's not big money.
I couldn't speak to Mr. Keller's characterization.
Thank you.
Does the board have any questions for this witness?
I do.
Please.
I'm totally confused on this Exhibit F, where Mr. Grisham says this is absolutely within the boundaries as long as everything is reported the way that you indicate. But the paragraph above it says is that then we will solicit in-kind contributions in the form of checks made payable to the vendor. So was that, but what I understand, none of your checks were paid directly to the vendor.
We are the vendor. Rio Strategies is a third-party vendor of the Keller campaign.
Okay. And then, and there's no other documentation other than saying a professional service, not what that service actually was. Because all of them just say professional service, but it doesn't say, campaign counseling or lawyering or.
Correct.
The way you report it to the city.
That's correct. I mean, it's reported as professional services or staffing or a variety of the things that were provided. We provide a wide variety of goods, services, advice, counsel to the campaign.
Any other questions?
I do, Mr. Chairman, Mr. Peckman. Going back to invoice 46, I guess it would be Exhibit C or A or...
I'm sorry, hold on one moment.
So when exactly was this invoice generated?
I'm sorry, when was it generated?
When was it generated? Yes, sir.
It was began, as the invoice says, on August 1st. Invoices are works in progress, get edited, go through drafts, get added to as time goes on.
Okay, and this was submitted to the Keller campaign at that time for services?
As I previously said, in September, I believe.
In September. Okay, that kind of answered my concern reporting, report 1, report 2, of course, within or before the time period. What concerned me was report 3 of in-kind donations dated 8/11. How would you forecast that particular?
Sure. So to keep everything as accountable and transparent as possible, we reported the in-kind contribution on the day it was received.
Okay, so again, we have a date here of 8/1, but then I have reporting for 8/11. So that was concerning to me as to why you have a date and then a post date with activity and in-kind contributions.
Sure. I think maybe the best way to explain that is to make sure that we were reporting everything as accurately as it came in. We reported the in-kind contributions the day they were received to Rio Strategies to be given to the Keller campaign. The invoice was our internal accounting system that we could use for the campaign to show how the services and goods that we were doing and how that money was being used and accounted for to ensure that it was totally accurate.
Okay. And then the other question, is this invoice reflective of all charges to the Keller campaign, or are there other invoices or activity that would be billed to the...
Oh, sure. There's lots of other invoices and activity billed to the Keller campaign. Those are reported on the public finance reports, and I'm happy to discuss those.
Sure. So this is just reflective of in-kind donations only?
Correct. We specifically wanted a clear accounting of the in-kind process, both in adherence to the cap, as well as making sure we, as I mentioned, that we had a tracking system catching the incoming and for reporting purposes, and then accounting for it.
Okay, very good. So you wanted to keep that separate then?
Absolutely.
Okay. And final question from me too is the solicitation process. Can you review that for the board again?
Sure. As I mentioned, the code allows for the in-kind contributions up to 10% of the allowable disbursement, and it was no secret that we were talking to folks who wanted to support the campaign about what that process was, and that you could not give money to the campaign once that public finance period was over. That there is this other way to make an in-kind contribution to the campaign, that you could do so by purchasing services in Rio Strategies, which would then be given to the campaign. And we were descriptive of the kinds of things those would be.
Okay. And the form that did take place in terms of the contribution was a check to Rio Strategies with the note that it was intended for the Tim Keller campaign, correct?
Yes. I believe all of them, almost all of them were. And yes, we would not have accepted it as an in-kind contribution without that Tim Keller.
So that was your preferred mode of accepting donations?
Absolutely. Clear, accountable, referenceable, and easily reportable.
And I guess what I'm asking, did you at any time have someone directly offer goods, as an example, say a case of water, or a service?
Sure. There are in-kind contributions that we reported. There was a labor union that made a video that was reported. There's office space that's been in-kinded by an individual. There are a handful of other things.
So there's other means to contribute overall?
Sure.
And that's what's reflective on this invoice?
The invoice is just the in-kind from Rio Strategies.
So monetary check donation?
Yes.
Okay. Very good. Thank you.
Other questions for this witness?
Yeah. I have a couple of questions, Mr.
Yes, sir.
Packman. I think you indicated in your testimony that you were a signer on the campaign account.
That's correct.
And the campaign account is the account that holds the public monies, correct?
That's correct.
Did you actually draw checks on that account? Did you sign checks?
Yes.
And those were paying campaign expenses?
Yes.
Were those expenses incurred by Rio Strategies?
Some.
So you would draw a check on the campaign account to pay to your company for campaign expenses?
Yes.
And some of those expenses, I assume the expenses that were paid with public monies would include items such as you have on invoice 46.
There are certainly some items that were paid with money, some were used as in-kind, and they could certainly be similar.
How is the decision made on what campaign expenses would be paid with public monies versus paid through the solicitation of funds by Rio?
So as people would pay Rio Strategies for services, we wouldn't want to spend money that didn't exist or something like that. So as the money came in, we would then assess where the needs were, what was needed at that time, whether it was printing costs or database costs. Some of it depended on when different things may have been due, to assess how to use that money as it was coming in.
So were you the primary person making the decision on how to allocate expenses paid with public monies versus those private monies?
We worked together as a team, Rio Strategies, to do that.
Was Mr. Keller involved in those discussions?
Mr. Keller was certainly aware of the needs of the campaign and what was going on. I couldn't specifically say which discussions which individuals were part of on any given item on that invoice.
You indicated that you represent a number of other campaigns.
That's correct.
And have over the years.
Yes.
Have there been other publicly financed candidates that you have used this arrangement of in-kind contributions for?
I have worked for City of Albuquerque municipal candidates in the past who have taken in-kind contributions, and yes, paying third-party vendors and providing services as outlined in that Grisham Gibson letter was sometimes part of that process.
And how many candidates have you done that for?
2.
And those were candidates that were running in prior elections, not this election?
That's correct.
And was the arrangement that you used for them virtually identical to what you've done for Mr. Keller?
Very similar. I don't know if virtually identical. I would have to go back and review. I have not reviewed any of those reports specifically in preparation for today.
And as I understand from earlier questioning, you've never gotten a legal opinion or an opinion from the city auditor or even the city clerk about whether that arrangement is proper or legal?
That's correct. As I mentioned earlier, the definition that was placed up of in-kind, what an in-kind contribution can be. It's in-kind goods and services. It seems very straightforward. No money may go to the campaign, and at no time did any money go to the campaign. They were paid to us, Rio Strategies, a third-party vendor, by the individuals, and that service was given to the campaign.
Okay. Thank you. I have no other questions.
Does the board have any additional questions? All right. In light of the board's questions, I'll afford counsel an opportunity if they have any additional questions before this witness is excused.
Mr. Packman, I asked you to produce all of the documents which would support this. I call it a scheme. You don't like that. But you produced no documents that would show that you personally or otherwise are aware of anyone soliciting private donors and listing on their campaign reports for professional services. Not a single document have you produced. Correct, sir?
I'm sorry. Can you repeat that?
You have never, ever, for any campaign that you personally participated in or seen anyone else list in-kind donations for professional services and the money be handled in this manner. Have you?
I wouldn't be able to specifically say. As I just mentioned, I did not review the previous reports in preparation for today.
I asked you to produce all those documents, and you didn't look for them. Is that your testimony?
I produced the documents in consultation with the attorney for the Keller campaign.
Thank you.
Any questions? Sorry. Any questions for the respondent?
No, thank you, Mr. Chairman.
All right. You may step down. Thank you, sir. We appreciate it.
Thank you.
Mr. Rogers, you may call your next witness.
Mr. Chairman, what's the time count?
After this witness, the complainant has 41 minutes remaining, and the complainant has 41 minutes remaining, and the respondent has 62 minutes remaining.
I would call Mr. Keller to the stand.
Mr. Keller, if I can ask you to raise your right hand, please. Do you swear that the testimony you're about to give will be the whole truth?
Yes.
Thank you very much. Mr. Rogers?
Mr. Keller, you understand this is an ethics board proceeding and you are under oath.
Yes.
And you understand your obligation to tell the truth, right?
Yes.
Ms. Hunt works for Mr. Pac-Man and Real Strategies, right?
I think she's a partner, so in respects, yes, but...
You've received, your campaign has received more than $500,000 in taxpayer money, right?
We're a publicly financed campaign, and we qualified for the amount designated by the clerk for both the first election and the runoff election.
So that'd be a yes to that?
I'm doing the math in my head, and I think it is right around that number.
Okay. Madam Clerk? Madam Clerk, could I have you turn on Mr. Keller, you're responsible for the public reports that are submitted, right?
Yes, I believe it's myself and the treasurer.
Your treasurer is who?
Liz McMasters.
And her name's not been mentioned, nor are there any emails to her. Did she have any part in this effort to obtain in-kind donations and list them as professional services?
I think everyone in the campaign had been working on all of these aspects, and from day one, we articulated what public financing entails.
Would that be a yes or a no? Was Ms.
Yes. Yeah.
She was. Okay.
Mm-hmm.
There are no. Your lawyers produced 3 pages to me in response to this subpoena that had 4 separate detailed requests. Is it your testimony, sir, under oath, that these are the entire responsive documents to the subpoena that was served upon you?
Yes.
And so, for instance, you no longer have the email that I asked Mr. Pac-Man for, email that you sent to him. You don't have that.
It did not show up.
Did you look for it?
I looked for everything that would be responsive.
How much time did you spend looking for it?
A lot of time, several hours.
What's to explain an email that's sent to Mr. Pac-Man and produced this morning that you don't have, sir?
It could be a number of things. I mean, you could ask that about any document in general.
I'll ask it about that one.
Okay, I don't know.
Okay.
It didn't show up.
And you looked in all of your documents?
Yeah.
All right. Okay. You, sir, are presently the state auditor, correct?
Yes.
And you, sir, are obligated to attend the training of the city clerk concerning the charter and rules, right?
I believe so. There's a number of trainings.
You attended, right?
I believe so.
You're familiar with the rules, right?
Yeah.
I've got the charter rule, section 4, concerning campaign financing, number 2. Would you confirm that I'm reading this correctly? All contributions of money received for the benefit of the candidate's campaign or the Measure Finance Committee shall be deposited in that account, and all disbursements shall be made from that account. Do you see that?
I do.
So that's applicable to you, correct, sir?
Yes.
And yet, money for your benefit was going to Real Strategies and being deposited in their bank account, right?
I'm I heard the testimony that you heard, so whatever you would glean from that.
Seriously, you didn't know that they were receiving checks and depositing it in their bank account? You didn't know that until today?
I know that I gave any checks that I got to Rio Strategies because that's what they were for, and we were explicit about that, and where they deposited them or what they didn't was up to them.
Well, that's an interesting answer, but it's not the answer to my question. Is it your testimony today under oath that you did not know that Rio Strategies was taking checks and depositing those checks into their account, whether they said in kind for Tim Keller or said something else? You didn't know that until today?
I mean, if I buy something from Walmart, I don't know where that check goes, where Walmart puts it.
So that'd be a no. This was news to you that Rio Strategies was putting money into their bank account, right?
Excuse me one second.
It's Mr. Rogers' time to burn up, but I'm going to object because we're getting to the point where it's repetitive. So I believe the chairman can order that he move on. He's asked this question now 4 different times, and he's gotten answers.
I'm not going to cut off any line of questioning. I've said this already several times today. Each time the floor is the attorney's, but I think the point about this becoming repetitive is a good one, and I would urge Mr. Rogers to move along.
As state auditor, what do you do when you find out a governmental entity that's supposed to have one account actually has 2? What do you do, sir? Is that a problem?
It very much depends, and I think as state auditor, I understand deeply what that depends on. There might be a number of reasons why they might have different accounts. There's nothing, to my knowledge, in auditing that requires anything about specific bank accounts.
So you're not,
their accounting is
you're
required.
Not familiar with any.
I'm not sure.
You're not required with any requirement in state law.
Excuse me.
I don't know the rules.
Well, I'll tell you the rules.
Sure.
The rules are each one of you gets one chance to talk. Please don't talk over each other. Please let the other one finish whatever it is they are saying or asking before the other one of you talk.
Okay.
Any questions about how we're going to proceed on this score? All right.
Sure.
So
I think I was finishing a point about auditing.
I'll ask you a question.
I'm trying to reset the tennis court here. So, Mr. Rogers, it's your serve.
Yes or no, Mr. Keller, you're not aware of any requirement in any government law, regulation, or GAAP practice that suggests that in one account is required or a good thing for purposes of accounting and auditing?
I mean, that question, I am aware of lots of things and lots of rules for lots of different governments. I'm sure somewhere there are certain times when you need a dedicated account, and I know there are all sorts of reasons when you don't. And so by definition, that is not a yes-no question.
So you don't have any problem with checks for your benefit being deposited by Rio Strategies despite the rule, the law, the requirement that you were trained on, which says there shall be one account for contributions received for the benefit of the candidate. This, which you just discovered today, doesn't give you any concern.
Well, as state auditor, I don't audit campaign financing or any private entities, so that question has nothing to do with audit rules.
You don't have a problem then with what appears to be a violation of a very clear rule that says there shall be one account for contributions received for the benefit of the candidate's campaign. You don't have a problem with the fact that there are more than one.
All right, hold on again. There's an objection.
I have to object. For the record, Mr. Chairman, this is immaterial. Mr. Rogers is essentially characterizing a legal opinion, and Mr. Keller is not competent to answer that, given that he's not a lawyer and he's a witness. He's a fact witness in this case. So we'd ask that Mr. Rogers be instructed to move on.
Well, I'm not going to make that instruction. Your point is well taken. Mr. Rogers, let's continue your question.
One of the rules requires that your campaign report the personal services of attorneys who are representing you, right?
I believe so.
you haven't reported the services of these fine criminal attorneys who represent you in any report, have you?
Boy, there's so much to object to, but I'm going to limit my objection, Mr. Chairman, to the fact that this is irrelevant and immaterial to this complaint. I understand that there has been some other complaint filed that is relevant to attorney's fees, but I'm going to object to this as being immaterial to this matter.
So 2 things. Number one, I agree with your objection with regard to the characterization of the nature of the law that you and Mr. Urias practice. However, just to make it very clear, there is no record here. You may see no court reporter, so I appreciate our legal training that ingrains in us the need to make an objection for the record, but
if you ask my family, I say that all the time, and at dinners and so on.
So your objection with regard to the characterization of the kind of law you practice is well taken. Mr. Rogers, the floor is yours.
Mr. Keller, you've not reported the services of these very fine attorneys, have you?
I know that I believe they are representing me, and I have not received a bill yet. I'm sure at some point I will get a bill for something.
How is that going to be paid from the committee, your committee?
I think it's a fair question. I believe they're representing me as a person, and in fact, this is Wayne versus me, not the campaign. So, but I don't exactly know how that's going to play out, but I'm sure the lawyers will get paid.
So the question is, why don't you report it if the regulations require that? And that's paragraph C of the rules and regulations of the Board of Ethics. You're going to report that someday?
Well, as I said, I haven't been billed yet, and I don't know, based on the complaint, it's to me as Tim Keller. So we'll see where that bill goes to, but that's what your complaint is about myself. Right?
So you don't think this is a complaint against you as a candidate and how you're handling money?
I think that is a good legal question, and I certainly do not have an answer to that. You filed the complaint, and it says Tim Keller, so you tell me why it's not Tim Keller for Albuquerque.
Well, Mr. Keller, this is an ethics proceeding about how you've handled taxpayer money and what ethics rules you may have broken in that capacity, okay? We got that?
I do.
All right. Mm-hmm. So what's the understanding? Are they going to bill you by the hour, or is there a flat fee, or what is that?
I do have to object, Mr. Chairman. We're getting into attorney-client privilege information. I'm going to instruct my client not to answer those questions.
Well, privilege notwithstanding, this is now becoming very immaterial to the nature of your complaint, Mr. Rogers, so I am going to sustain the objection on the grounds that it is becoming irrelevant and immaterial and not directly relevant to the issues that you have presented. So please move along.
You decided not to request an advisory opinion to approve this procedure that has resulted in an additional $38,000 to your campaign, right?
$38,000 in in-kind donations is permissible and always has been on every campaign, and so I felt this was a transparent and an accurate way to account for that money. And I didn't really see a need for an advisory opinion. I certainly asked about it a lot, and I got an answer that I thought made sense, in that we're tracking everything, and it will be allocated to a specific something with a specific dollar amount so that we don't cross the cap. So
you produced three pages, and it's dated June 20th. In response to that 4 items of subpoena, you produced 4 pages, and in it, Mr. Pac-Man is quoting Ms. Hunt that basically that she finds this acceptable. Is this the authority that you relied upon to continue to collect dollars from private donors and list those as in-kind contributions for professional services? It's this 3-page document?
Well, as you can see, I don't have a copy of that in front of me, but I know the board does, and that was kind of looked like a checklist of things I wanted to make sure we were, and I believe the 100% word was in there. We're 100% sure X, Y, Z. They said yes. Rio Strategies has worked with dozens and dozens of campaigns. I've worked with them before. They're currently working with other campaigns, so I saw no reason to fourth and fifth guess what they said.
Fourth, they're not attorneys, right? Neither Mr. Pac-Man or Mrs.
No, they are not.
Okay. And so when you say fourth and fifth guess, that would mean you don't want to second guess people who are not attorneys and have not requested anything in writing from the clerk or requested an advisory opinion. Would that be a fair summary?
Well, they have run lots of campaigns, as you mentioned, a couple of city publicly financed campaigns. And also, I know we had been reporting this for several months. And I know the clerk's role, is not like they didn't give a legal opinion, but the whole city knows what we were doing because we were filing it every month. And so, the auditors, there was no comments made. There was nothing made until right before the election. So I had a degree of confidence that this was the right thing to do. And in fact, that's because I actually thought this was a better way to do this in-kind issue.
Mr. Chairman, I'm going to have to ask that the filibuster stop, unless this is not on my time. This is not responsive to the question whatsoever.
I am trying not to tell either the lawyers or the witnesses how to perform. And Mr. Rogers, I've given you as much leeway as I could when questions were going far afield or were being asked several times. I'm going to give the witness the full opportunity to answer the question. That being said, Mr. Keller, I would appreciate if you could try and keep your answers more direct to the questions being asked. Your lawyers will still have an opportunity to question you if there are other issues that you did not get a full opportunity to expound on during your time with Mr. Rogers.
Sure, understood, and I won't filibuster, done that before. I do think, though, pursuant to your question, it is important to note that we did this, and I did this, because we thought it was a more accurate way to account for in-kind donations. That's very material, it's very important. If you are going to give me that can of soda, it might have cost $1 or it might have cost 50 cents. And as someone with some background in accounting and finance, I would rather know the value of that and account for it. And so I actually thought this was a more accurate way to do it.
Well, let's ask you about your background in accounting and auditing. How does this procedure differ from someone writing a check directly to your campaign, some private donor writing a check directly to your campaign, then Mr. Pac-Man making a decision about should it go here, should it go there, or wherever? How does this differ from a person writing a check directly to the campaign? Because you're not listing on the public report anything other than professional services. There's not a single document that suggests these people were buying goods or services as that invoice 46 dated August 1, but clearly prepared after that. So how, sir, does this differ from a check paid directly to your campaign?
It differs in a couple of key aspects. Number one, it's a vendor. So it's the same as a check to Kinko's or Walmart or a law firm. So that is the biggest difference. The second difference is that it says in kind in the memo. We were very explicit about that so that we could track that. And the third difference is it's capped so that everything is reported and we know when we hit that cap just as any other donation would be. And the last thing I would say, it's actually more accurate than what you're describing. That's why we did it. So we would know exactly how much money had been donated in kind.
Section 8 of the, we'll skip that. So did I understand correctly, Mr. Pac-Man decided how the public reports would be listed, whether it said for professional services or whether it listed something else on these in-kind donations? Were you responsible for any of the determinations that appear on your public reports in that regard?
You know, the categorization of the line item in these reports, I believe, is a drop-down menu, or there's a series of choices. That was made certainly by the campaign, and the treasurer looked at that, and whether they're professional services or what they're categorized. That's an administrative issue that comes up often in the city audits, and we're correcting that a lot. And so this never came up, and so I didn't see any issue with it.
In the answer to my question, you didn't take any part in that determination, did you?
You have to have a...
Yes or no. Did you participate or did you not in the characterization of the items that appear in your report that you signed?
The reports are listed. You have to log into a computer to do them, and so I did not participate in that. I did look over each report when it was completed to make sure that I thought everything was okay.
So, yes, you did participate in the characterization of these in-kind donations.
I always looked over every report, and as I've said before, we were doing this all along on purpose because we thought it was more accurate, and so that was a decision I made.
And the reports reflect payments to Rio Strategies throughout this process. Is any portion of Rio Strategies' compensation dependent upon how much money they might raise through this in-kind for professional services effort?
No.
Is any portion of their compensation based upon a win?
No.
Let's talk about those expenses just a little bit more. It's in your book, but you may or may not remember this. On 7/11, Rio Strategies was paid $14,201.60 for a staff salary. I guess that's a regular monthly payment or something to that effect.
That sounds correct.
And so both the campaign and Mr. Pac-Man would have invoices or other documents for that expenditure, right?
I believe what you read was a invoice for an expenditure.
No, it's from your report. It's actually...
Okay.
So you're an auditor, so you've got invoices and you've got documents to support all of these payments to vendors, right?
Why would I have those? Those are Rio Strategies. That's their bookkeeping. So
they don't send the campaign any information about their charges?
It's all part of the campaign finance report, and so that's our public report and accounting of record, and that's what I pay attention to.
Does your campaign require invoices and billings from vendors?
Our campaign requires compliance with respect to the public financing report, and that is how we account for every dollar.
So you require invoices or billings, or do you not require invoices and billings from vendors?
I don't think in any campaign that I've seen or run where the individual has a requirement for those kinds of different things, that in this case, Rio is the vendor who is running the administrative back end, and so that's their responsibility.
On that same day, July 11th, your campaign paid $15,000 to GBA Strategies for research. Did you see that invoice, sir?
Did I see the invoice or
Yes.
the reporting of it in the campaign finance report?
Did you see the invoice that your campaign received for $15,000 from GBA Strategies?
I don't believe so.
What was the total invoice? Do you know?
I just shared that I don't believe I ever saw
What did
that.
GBA Strategies provide to the campaign?
They provide research. They provide all sorts. They're a company that services. I mean, they're kind of the Walmart of Democrat research. So,
did you see their research? Did you see the product?
Yes, I did. Yeah.
And how did that differ from the $15,000 for research that they provided to the Measure Finance Committee that's supporting you, sir?
I'm going to object.
Yes.
Thank you, Mr. Schultz. I'm going to object. This is related to another complaint that's not before the board. It's immaterial to the complaint that has been filed in this matter that is before this board today.
That's a fair point. So, Mr. Rogers, can we circle back and continue on this matter that's before us today?
So So that question will not be allowed on the basis of relevance, if I understand?
Thank you for making my ruling much clearer. Yes.
Okay. Very good. In 2005, did you vote in the municipal election?
That is a great question. Who was on the ballot? Because that would help me remember.
Mr. Cadigan was on the ballot.
You know, in 2005, I was in graduate school, so I doubt it.
Okay. So you weren't here to vote or receive the voter's guide from the League of Women Voters of Albuquerque and Bernalillo County, were you?
I don't think we get that in where I went to school.
I'll bet you don't. So you weren't here to see the basis that the public received for voting for this plan to allow taxpayer dollars to be used for campaigns. You weren't here.
I usually come back for Thanksgiving, Christmas. So, I mean, I was not living here, no.
Right. So the League of Women Voters on for the October 4th, 2005 election, this is what they told voters in order to get them to agree to use taxpayer dollars for private campaigns. Let me read this. In exchange for getting disbursements from the fund, candidates would not be allowed to accept or spend private campaign contributions. You were not aware that that was the basis that voters were given to endorse this plan, which is resulting in billions of dollars of taxpayers' money being spent, right?
Well, I'm aware that in-kind donations are permissible under the code. In terms of how the league characterizes that, this is a long-standing issue that, that's their publication, so.
I asked you for any document that supported your position, anything had to do with in-kind, and I get 3 pages. There's nothing in there to support what you're suggesting, that everyone knows that in-kind, that you can do this for in-kind money, is it?
I did not publish the election code or the city charter, one, because those weren't in my inbox, but also that's what we've been citing for the basis for this. And those are publicly available documents. So that would be my evidence for doing this. That's what it would be, the code.
So you're going to stand on the code. That's your story, and you're sticking to it. In-kind contribution, a good or service other than money, right? That's your position. That allows your campaign to take and solicit from private donors, contrary to what the League of Women Voters said right here, that your campaign, after you get $500,000 in taxpayer money, you can then supplement that with private money up to $38,000. Is that right?
The code allows for $38,000 roughly of in-kind donations. I don't think there's any dispute on that. I'm not sure. I can't speak for the League of Women Voters, but I don't think anyone disagrees with the fact that we can have in-kind donations.
With regard to looking at your subpoena for the documents, were any documents removed because you felt they were privileged or otherwise didn't have to be produced?
No.
And you understand that it's an advisory opinion that provides a defense. And you understand you could have requested an advisory opinion, just like you did with regard to the runoff, right?
What I understand is that we felt this was a better way to do things, and so there was never a need to get layers and layers of opinions. I have learned a lot about how advisory opinions work since the news story, and so I learned a little bit there. I don't know what else to tell you.
So if you decide not to get an advice, if you'd asked for an advisory opinion, the answer may have been no, and you would be $37,000 short in your campaign with money that you can spend, correct?
That's actually not the campaign.
Mr. Keller, hold on one second. Your attorney has a point.
I am going to object. That is a statement that is really basically a legal conclusion. It calls for speculation. It's irrelevant and immaterial to these proceedings. If he had gotten an advisory opinion, it probably would have said no, is not relevant to these proceedings.
That's not how I heard the question, so the objection will be overruled. Mr. Rogers?
If you'd requested an advisory opinion and the answer was no, you'd be $37,000 short now, wouldn't you?
I mean, I don't know. It depends on that opinion, and how could I mean, that is a hypothetical, so I don't know is the answer to your question.
And I guess under the old guise, it's better to ask forgiveness than permission. If, in fact, the board finds that you violated this, if they do anything short of a fine of $37,000, your campaign still has benefited from this, haven't they?
We believe that we did everything in the right way, and so I'm not really bothered by one ruling one way or the other, and I respect the board's opinion, and I'm glad we did public financing, and I guess we're done.
Just to be clear, I assume that means you have no further questions?
Correct, Mr. Chairman.
Questions for the respondent?
Before I begin, Mr. Chairman, may I make a time inquiry?
Give me 2 seconds, and that does not get charged against you. Yes, the complainant has, after the questioning of this witness, the complainant has 13 minutes remaining. The respondent has 61 minutes remaining.
Thank you.
Mr. Chairman, can I ask a question about timing?
Sure.
So the 12, do we end at 12 no matter what, or we're like, because if you add those two numbers together, it's more than the total minutes left.
And I don't want to argue with an auditor, but no, the way this has, the way each side gets 90 minutes. There have been other matters that have gone on. I have made comments. There have been questions from the board. There's been some shuffling of papers back and forth that I've tried not to charge against either party. Sure. But what I am keeping to is the 90-minute requirement per side. That is what I am keeping track of.
Okay. Normally I get a little scared when my client goes freewheeling with questions to the jury, but that was safe. Good morning, Mr. Keller. I just have a few questions to follow up on based on Mr. Rogers' questioning. But first, let me ask you if you could describe to the board very briefly a little bit about your education background, your history, and your history in the political realm.
Sure. So was born and raised here in Albuquerque, went to Our Lady of Annunciation till 8th grade, and then over to St. Pius. And then I went away to school, got a finance degree from the University of Notre Dame, and maybe about 5 years after that, got a business degree and MBA at the Harvard Business School.
And then at some point you moved back to New Mexico, is that right?
Yes.
And do you remember what year that was?
It's got to be around 2008.
Okay. Mm-hmm. And you have served in the Senate, is that right?
Yes, I served 2 election cycles in District 17, Albuquerque's International District.
Okay. And was that your first elected position?
It was. I had a brief stint in California where I ran for neighborhood association board.
Okay. Okay. After serving in the New Mexico Senate, did you then run for office for state auditor?
Yes, I did.
Okay.
Yeah.
And what year was that?
I think the campaign would have been in 2013, and those are long campaigns, so it ranged over the course of 2 years, actually, the statewide campaign.
Okay. Why did you want to run for state auditor?
You know, as state auditor, there were a couple of things. I had worked diligently as a state senator to try and get to the bottom of tax reform and tax expenditures, tried to understand how much money was leaving our state in terms of contracts, and also tried to understand what was happening with our procurement code, all of these big issues that I ran hundreds of bills on. And I learned that as auditor, I actually could probably just do them myself, and I didn't have to pass laws on them. And so my agenda has pretty much been to finish the ideas that I started in the Senate, and I think we've done a pretty good job for that. And also it was a good fit for my background. I think there's actually, not being a lawyer, there's not a lot of positions in government that really utilize a finance background. And so that was very attractive to me too. I was like, wow, I might actually be able to use some of the things I was educated on.
Okay, thank you. Is the sort of the use of public monies, is that something that you find to be important, the use and abuse of public money?
You know, absolutely. I mean, the cornerstone of the auditor's office is, of course, fraud, waste, and abuse. And we've seen, whether it's been athletic directors, school board members, superintendents, elected officials, cabinet secretaries, for the last 3 years, I've been cracking down on fraud, waste, and abuse and holding folks accountable for spending public money appropriately.
Okay. I want to turn to your campaign for mayor that brings us here today. And I want to ask you about basically what is the Keller for Albuquerque campaign. Who is the Keller for Albuquerque campaign? Who staffs that campaign?
You know, because of public financing, it's basically my wife and I and my in-laws and my parents, and then over 100 volunteers. It's a special thing to see that many people wanting to volunteer to try and make our city better, and that's what our campaign has been about. And I think it's demonstrating that we can do things differently.
Okay. Now, as part of running a modern political campaign, obviously you need to have some sort of management services. Is that right? Is that fair to say?
Yes, and this is I think it's my 5th election, and so I've seen this. When I first started, had to hire a consultant to do things like, put together your mail program and databases, and as you get a statewide campaign is such a huge geographic thing. You're doing using a lot of different vendors geographically in different cities. And then now for this race, because this is a major media market, there's all sorts of consultants and things and services that you need around understanding media buys, things of that nature. And also databases and IT and back office administration, especially with the reporting required for public financing. These are all things that you've got to use professionals for who've done this before.
And so have you contracted with any firms, companies, to provide those types of services that you described?
Yes, yeah.
And is Rio Strategies one of those firms or entities that you contracted with?
Yes, they are.
I want to be clear, because I think there's a little bit of I was certainly confused when I first got into this case about sort of understanding a modern campaign. Is Alan Packman an employee of the Keller for Albuquerque campaign?
No, he's not.
Okay. Is Jesse Hunt an employee of the Keller for Albuquerque campaign?
No.
Okay. Are they independent contractors? Are they vendors that provide services to the Keller for Albuquerque campaign?
Yes, absolutely, and that's pretty much how most modern campaigns work.
Okay. When you say that, do you know of other examples of campaigns using independent contractor, third-party vendors to provide these type of campaign-related services?
I do. I mean, I think almost everyone I can think of. I know most of the mayoral candidates did that as well. Certainly, every governor candidate I know, most of the congressional candidates. It's a rare occasion in this day and age when anyone does not have paid consultants and vendors.
Okay. So when Mr. Rogers was asking about the one bank account, in fact, I think he left his note up here. I'm going to hand back to him. About there being one account for the Keller for Albuquerque campaign, and the checks made out to Rio Strategies being deposited in the Rio Strategies account. Would those two accounts be the same account for any reason? You don't share a bank account with Rio Strategies.
No,
in a different way.
No, because they're a separate vendor, just like I wouldn't share it with Kinko's or Costco or anything else.
Okay, so a check made out to Rio Strategies wouldn't be deposited into the Keller for Albuquerque bank account. Is that right?
That's correct.
Okay. Now, Mr. Rogers asked you about not seeking an advisory opinion with regard to these in-kind contributions that were made to the Keller for Albuquerque campaign. And just for the board, for clarification for the board, why did you not seek an advisory opinion with regard to the in-kind contributions that are at issue here?
Yeah, I felt we were doing this in a way that was actually much more transparent and accountable and accurate. And so I didn't think we needed an advisory opinion. This is a method where you can actually account for every penny. And I think, the learnings, while the auditor's office has nothing to do with auditing this, what I've found is the more accurate you can be and the more straightforward you can be, the better. And I think that also speaks to, even if there is ambiguity or gray areas in different laws, as long as you're upfront with where every penny went and you're being transparent about that, then you're doing the right thing. And so I thought this was actually an improvement on the way others had done it.
Okay. Having read the charter, the code, do you believe that there's gray area about what you did? There are ambiguities about what you did, the process that you followed.
Objection calling for legal conclusion, which he insisted he would never provide.
May I respond?
Wait, please. So is this, are you arguing relevance, immateriality, unduly repetitious?
Waste of time and relevance. And if the objection is going to be recognized for one side, it should as well.
Understood.
Thank you.
No, you can respond. I haven't ruled on the objection.
Oh, thank you. I don't think this is a good for the goose, good for the gander situation. He was being asked about hypothetical or speculative legal interpretations. My question to Mr. Keller, not as a lawyer, but as a candidate for mayor, is whether he believes that the process they followed is consistent with the code and his obligations under the code.
I'm going to allow the question. There were similar questions asked earlier. So, and there have certainly been similar questions asked of the previous witness. So I'm going to allow the question.
Thank you.
Yes.
Now, you did seek an advisory opinion regarding in-kind contributions during the runoff election, which we're currently in now. And why did you do that? Why did you seek an advisory opinion with regard to that process?
I think there were a couple of reasons, but the first one is that our code, the runoff world is very unclear. It's very different than the first election, or whatever we want to call it, the general election. And so that was the overwhelming reason. I think the other reason too is that I felt that at the end of the day, that was a tool that needed to be asked because there was no guidance in the code. So, previously I thought, look, this sounds good. This is a better way to do it. It's transparent. It's accurate. Runoff, it was like, I have no idea what the rules of the game are. Let's ask.
Okay. And have you abided by that advisory opinion that said that in-kind contributions were not allowable during a runoff election?
Yes.
Okay. Now, Mr. Rogers asked you questions about the collection of money for your campaign. Just to be perfectly clear for the board, were these checks that were going to Rio Strategies, was this money going to the Keller for Albuquerque campaign?
No, they were going to vendors, Rio Strategies.
Okay. Did you ever receive cash from Rio Strategies?
No.
Okay. In fact, it's been the opposite, generally, correct?
Right.
It's a one-way ratchet. Okay. And did you ever receive cash from an individual that you just sort of pocketed to use for your campaign?
No.
Now, there have been a lot of inflammatory allegations tossed around in this case, words like money laundering and funneling and all kinds of words that have been sort of used to suggest some nefarious scheme, as Mr. Rogers has said. As an auditor, as the state auditor, do you have concerns about that sort of what I think can be fairly said is an exaggeration?
You know, I do. I think it's irresponsible, and I think it makes the public financing system and the city of Albuquerque look completely inaccurately flawed. And as auditor, I could never get away with that. There is a reason why we are accurate and proportional in our findings and in our accusations. And we understand I would never accuse anyone of an actual crime, ever, without having significant evidence, and then I would use the words alleged. We see administrative issues, gray areas, and audit rules dozens of times a week. And we work with the entity to understand what is the right answer, and sometimes we write them a letter, sometimes they agree just to do things differently, sometimes we agree that we're wrong, which actually happens quite a bit. That's the appropriate way to deal with administrative questions. I don't think it serves the public any good to throw around terms that are either misdemeanors or felons or criminal in nature when there has never been a factual accusation in anywhere, even from the evidence presented on either side, of anything that has anything to do with something like money laundering, cash under the table, these kinds of things. They're just absolutely wrong. And I know why they're doing it. I have made a lot of enemies by going after the well-connected and the powerful as state auditor in standing up to the special interests in this state. And they do not want me to be mayor.
I'm going to ask you one final question, and that's, why did you follow this process of receiving in-kind contributions in this way?
You know, I remember hundreds of house parties that we had to have to get the $6,005 donations to qualify for this. And at almost every one, I would say that public financing looks like Neapolitan ice cream. You've got 3 flavors: seed money, the $5 donations, and in-kind, which is capped at $38. And I said that the best way to account for the in-kind donations was to make sure that we have a check going to a vendor and that it specifically says in kind. And that way there's no dispute over the value. Because people offer you things all the time, vehicles, refrigerators, all sorts of different things from their business. And there's no way to determine that value. That is where, as an auditor, I'm not going to accept a loan of somebody's copier or something like that because I have no idea what the value of it is. And actually, I think that is what gets candidates into issues with the ethics board and with the clerk, is the notion of what is an accurate value for a good or service. This way, there was no question about that. And that's why I thought it was a better way to do things.
Okay. Thank you. Pass the witness.
Are there any questions for this witness?
Mr. Keller, with regard to these in-kind checks that went to Rio Strategies, were you involved in soliciting any of those checks?
In every single meeting that I had with folks, I would use that Neapolitan example of how public financing works.
Well, with respect to the donors, the ones who made out these checks to Rio, do you recall speaking with any of those specific donors about making an in-kind contribution?
Yes, and like people would ask how to help, and I'd say seed money, $5, or in-kind, it's capped at $30,000. If you want to do in-kind, you have to write it to a vendor, and you have to put a memo in the memo in-kind for Keller. I mean, and we hit the cap. I had to return lots and lots of checks once we hit the cap, and so yes, you know, that was explicitly what I was doing on the campaign.
Okay, and did you tell those donors specifically to make the check out to Rio Strategies?
I did, yeah, and they would ask too, they'd say, well, how does this work? And I'd say, well, the cleanest way to do it is to make it to Rio Strategies, and they'll account for everything so we don't hit the cap, and they'll allocate it to whatever is appropriate. Yeah, I said that hundreds of times.
Okay, did you tell them what specific expenses would be covered by their check?
I would use examples. So I'd say Rio will figure out if it's postage or printing and that kind of thing. And printing is for a field campaign, printing is often the biggest expense. So I would always cite examples like that. And database fees too is another one.
Did some of those donors actually hand the check to you?
Some did, in which case I would give it to Rio. Yeah, some mailed it, and obviously if they gave it to me, I just give it to Rio.
Okay.
Mm-hmm.
Thank you.
All right, in light of the questions, or any other questions from the board?
I do have a question, Mr. Chairman. Mr. Keller, with regards to the code, was there a discussion as far as definition of in-kind contribution and limitations therein?
Sure, you mean kind of with Rio and that when you say a discussion?
The actual code, I mean, because I understand the rationale of why you decided to accept in-kind contributions, but looking at the actual definition, and again, reciting again, a good or service other than money. So the money part is where I think the question lies in the ambiguity. What was your thought process or counsel on that particular matter?
Yeah, the question was around services in particular. So the idea was that we did have all of these different examples, and I'd say, okay, well, if somebody wants to pay for signs to be printed, and they're writing a check to the sign printing company, do we get the check? Is there a receipt? I went through all sorts of hypotheticals and came back to that the cleanest way to do it would actually have Rio basically consolidate that and then allocate it so that we could track it.
So as a matter of accounting, Rio Strategies was a preference in the model that you used, but again...
Yeah, that's true. Mm-hmm.
But again, the money part, though, I guess, is where the ambiguity lies. So I'm not sure how we get around that, or how the code really defines that and limits it to the candidate, or how it applies to a consulting group or third-party vendor.
Yeah, my thought was the money has to go, in other words, so like if it went to Kinko's, there would be money going to Kinko's. So I wanted to keep track of that money. So I guess I read money as part of the equation no matter what. What I thought the intent of the code was that you're not just taking, bundles of cash that are unaccounted for and that kind of thing. So I felt that a check that someone writes for any service was the same as a check to Rio because they're a vendor.
Okay. And then the final question, I know that the reports reflect in-kind contributions. I was looking at the invoices and the reporting from Rio Strategies to your campaign. There seems to be discrepancies, and I guess we can look at that at a later point. But I'm not sure what was taken out, what was put in. Again, just looking at from your counsel, the exhibit or invoice 46, there's an added line item on there. So I have two different invoices that I'm kind of concerned about the monies involved here. Yeah,
I noticed that too, actually. And it's my understanding that was, I think this is just something that happens when you are fulfilling a subpoena. That was an invoice, I believe, that was before the final one, and I think they added more. Or there was a minor change, I think, to software went to database. But I do remember that email I think it even said draft in it. So I saw that as well. I saw that as just a reflection of them continuing to fulfill the invoice.
Okay, so just clarifying on additional charges and deletions.
Yeah, and I believe it was I think like software changed to database or something.
It was actually printing $700, $722, and then
Okay.
a discount of 2 cents.
Thank you. Your memory's better than mine, yeah.
Right, yes. So,
Yeah.
and again, I guess no further questions. Thank you.
Thank you.
Any other board questions for the witness? In light of these questions, do either counsel have any further questions?
No, Mr. Chairman.
Mr. Coe, thank you. You may step down.
Thank you, members.
All right. So the current time total is complainant has 13 minutes remaining. Respondent has 45 and a half minutes remaining.
Mr. Chairman, I'm going to have to ask for a very short break for reasons that I don't want to go into. But I would also like to ask, Professor Sierra indicated she's got other obligations, and I'm sure some of the other witnesses do as well. I'm prepared to release the witnesses when they give me their documents. So I believe that a 10-minute break would serve all of us.
Well, here's what I'm going to suggest. I believe your suggestion for a 10-minute break is exceptionally warranted. Let me urge that in addition to whatever else has to get taken care of during that 10 minutes, that counsel confer with regard to the issue of remaining witnesses and documents to be produced. And then when we come back, the first order of business will be for me to hear from both counsel as to where we stand in that regard. So we will be in recess for 10 minutes.
Mr. Chair. I do think Ms. Sanders, I know, is representing Ms. Denish.
Sorry, Maureen, I'm sorry.
Yeah, I'm sorry. So Ms. Denish and I both have other responsibilities at noon. I'm representing her. She had been served with an inappropriately served subpoena. She came today because she knew about the hearing, but the subpoena also requested documents from her, and in light of the inappropriate service, she has not brought those documents and has not had an opportunity to go through and even look for the documents since she has been out of town on 2 trips since the subpoena was dropped through her mail drop at her house, I believe on either the 26th or the 27th.
Okay,
and I'm raising it now because Mr. Rogers says he will release the witnesses once they give him the documents. Ms. Denish does not have any documents today.
Mr. Chairman, can I resolve this, perhaps?
Well, this is what I'm going to suggest. This is why I want to take a 10-minute break. I don't think there's a need for the board to be involved with whatever discussions all council may have. Let me suggest that we do that. And in light of that, let's come back in 7 minutes so that will still, if necessary, give me time to hear from Ms. Sanders with regard to any unresolved issues. So we'll be in recess for 7 minutes. Thank you for bringing that up, Ms. Sanders.
Okay. Well, so she doesn't want to produce them at any time, I think. Would that be fair?
I don't think that asked.
Okay. Well, that's all I need. Anybody else got any documents?
I don't think Sierra does, and I don't think Mr. Crawford does, based on my talking to him today.
David, can you go get Molly and we'll get back? Oh, there she is. Thank you. Sorry, I was... All right, let's go, well, see, you almost got me doing it. I was about to say go back on the record, but that's not true. So let's go back. And so, Mr. Rogers, we'll start with you. You had a suggestion about how to proceed in order to help expedite a few of the issues with witnesses and documents. Were you and Respondents' Counsel able to agree to something?
Correct, Mr. Chairman, members of the board. I'm happy to say that witnesses produced documents. Obviously, I don't know if they were all or so on. And the only witness that did not, Ms. Denish, Ms. Sanders, assured me that we would work out a reasonable subpoena and she would provide documents at a later date. So I think we've gotten the documents we're going to get, and I've released the witnesses, the remaining witnesses.
Okay, and is that consistent, Ms. Nora?
It is.
Okay,
yes.
Great.
Thank you.
Well, Mr. Rogers, I know you finished with your second witness, so the floor is still belonging to the complainant.
I have no more witnesses, Mr. Chairman.
All right. That concludes the complainant's case. Respondent.
Mr. Chairman, I believe that since we've already examined really who would have been our witnesses.
Look, I'm sorry, can I ask you to come to the microphone? The city clerk gave me a reminder to remind both of you.
Mr. Chairman, I think we have one witness to call. The others were called in the complainant's case, so I think that we have one, and I don't think it'll take much time, but I would like to get an idea of how much time we have. I think you said 40 minutes or so?
Yes, so where we are is the complainant is at 13 minutes, and the respondent is at 45 minutes, 30 seconds.
That's good. I don't think it will take us that long. Hope everyone appreciates that. But we do have one more witness. We have one witness to call in our
okay,
case.
Well, it is now your case, so the floor is yours.
We'll call Michael Cadigan.
All right, if I can ask the witness to raise his hand. Do you swear that the testimony you're about to give will be the entire truth? Great, thank you. I think you need to push the button to get your microphone on.
Test.
Can I ask you to say I do one more time?
I do.
Thank you very much. Mr. Urias?
Thank you, Mr. Chairman. Good afternoon, Mr. Cadigan.
Good afternoon.
Can you please state your full name for the record?
Michael Cadigan.
And what is it that you do for a living, Mr. Cadigan?
I'm an attorney in private practice.
All right. Have you ever held a public office?
Yes, I sat at this dais for 8 years as a city councilor from District 5.
Were you involved in the efforts by the city of Albuquerque to create and put together the public finance system now in place?
I was. With the help of Councilor Griego and Common Cause New Mexico, we were sort of the primary pushers of that effort.
And as part of that process, did you have the opportunity to study public finance systems that have been in use in other jurisdictions and in other places outside of New Mexico?
Yes, we were, and we primarily relied on the Arizona statute, which I actually worked on a very early version of that back in the early 80s, and so a lot of Albuquerque's rules were modeled after the Arizona experience.
Okay.
And other states as well. Since we did it, other states have come on board with public financing.
Okay. We've been talking a lot about terms like in-kind contributions and cash contributions and some other terms that are in the public finance system here in Albuquerque. In your studies of public finance systems elsewhere, are those terms that are typically used in these kinds of systems to describe the kind of contributions that can be made?
Yes. Every other public financing statute that I've looked at, and especially Arizona, which is the one that we looked at most closely, has a specific permission for in-kind contributions to publicly financed candidates in addition to the public money that is made available to the candidate. And in all cases, they define, well, at least in the Arizona experience, they define in-kind to include both goods and services.
Okay. And you've seen the definition here that has been shown a couple of times regarding the definition of in-kind as being goods and services other than money. I think there was even a question from the board regarding that aspect of it. And can you explain to us, based on your experience and knowledge with public finance systems that you've seen, including the system here in the city of Albuquerque, how does that fit into the discussion that we're having today as far as what can be received by a candidate?
The term other than money is again borrowed from the Arizona definition of in-kind contributions. It's slightly different in Arizona, but it is intended to distinguish between contributions of money directly to the campaign, to distinguish that from a contribution, an in-kind contribution provided by a donor, whether it's through a vendor or a professional servant. It's to distinguish between contributions of cash going directly to the campaign, or, as Mr. Keller pointed out, an issue that has been an issue in campaigns in the old days was people just giving cash, literally $100 bills to candidates. And so that is designed to make sure that when we're talking about in-kind contributions, we're not talking about taking a $100 bill and giving it to the candidate. We're talking about you go buy goods or you go buy services from a third-party vendor. That's an in-kind contribution.
So the focus is what you're saying. The focus is on what the candidate receives.
Exactly. In this case, the candidate received services and some goods. He did not receive cash. The candidate did not receive money or cash in this case. He received services.
He received what would have been defined as in-kind contributions.
Yes, because in-kind contributions is defined here and most other places as goods or services.
You and I have talked about this recently, correct? When you explained exactly what you just told me now.
Yep. Yes, sir.
And I want to show you this demonstrative here. No, I'll show you Mr. Rogers first.
Mr. Hughes, if I can ask you to speak a little more into the microphone.
Sure. Sorry about that, Mr. Chairman.
Thank you.
The demonstrative, and I don't know if you can see it from there. This is not. We don't have a court easel or anything, but. I think you had actually drawn a little diagram for me to help me kind of explain this, but this is Tim Keller's campaign, correct, or Tim Keller?
Yes, sir.
The public finance laws allows for Mr. Keller to receive $380,000 in public finance money. I guess in actuality it's $342,000 after the seed money is subtracted, correct?
Yeah, it changes, so I don't know the number exactly, but yes, the seed money is subtracted. That's correct.
Okay. So he is allowed under the provisions to accept that kind of that money from the public finance
as sort of cash or money. Yes, sir.
He's also, and this is part of, I think, and correct me if I'm wrong, but there are in the typical public finance systems provisions for in-kind goods and services.
Yes, that's almost uniform. That even in all public finance systems that I've looked at, there is some provision for in-kind goods and services in addition to the public money.
And the services that are in that definition, goods and services, does that include things like professional services?
Absolutely. And in fact, the city, the board, Board of Campaign Finance rules discusses professional services being contributions, in-kind contributions, or being contributions, and the definition of contribution includes both money and in-kind contributions.
Let me get back to that in just a second.
Yes, sir.
You said the rules of the Board of Ethics, the regulations?
Mm-hmm.
I'll get back to that in just a second. But I want to ask you first about this before my arm falls off this. The bottom there says focuses on what candidate receives. This is what you were just talking about a while ago.
Right, because Tim Keller's campaign, neither Tim nor his campaign received these cash contributions. They received goods and services purchased. They received the services and the goods purchased by these in-kind contributors.
And does it make any difference at all that there was money exchanged at some point to purchase those goods and services under the public finance, the typical finance system, and then the New Mexico public finance system?
No, I think that every in-kind contribution involves a cash or a money transaction. Someone gave the example earlier. I'll use donuts. Donuts are a classic in-kind contribution. You got people going out to walk for the morning and somebody makes an in-kind contribution of donuts. Well, unless you grow the wheat and drill the water well and harvest the sugar, you paid money to some third-party vendor to make those donuts and then give them to the campaign. So that's functionally the same as a third-party in-kind donor paying Rio Strategies to provide either goods or services to the campaign. It's the same thing. The focus from the ethics point of view is transparency. It's the most important thing is that the candidate not go over the cap, which is pretty clear, the 10%, and that it is clearly and accurately disclosed to the public. The idea of all of this is to minimize big money in politics and maximize transparency, and that's what this both the ordinance does and the charter, and that's what I think the Keller campaign did, was they limited the in-kind contributions to 10% as provided by law and provided maximum transparency.
Okay. Let me ask you a little bit about that. I take it that you've been sitting here all morning, correct, listening to the testimony?
Yes, sir.
You know what the allegations are in this case?
Yes, sir.
I think now we're to the point where we have a scenario in place. We have donors providing checks to Rio Strategies, and Rio Strategies then providing services and goods to the Keller campaign. That's
how I understand it.
Okay.
Yes.
First tell me, is that an in-kind contribution being made, and who is it that's making the in-kind contribution?
Well, that is clearly an in-kind contribution because, again, it is just like any of the traditional in-kind contributions. You have to pay some vendor for the thing that's going to the campaign. Otherwise, it's volunteer services, which is a totally different definition. So all in-kind services involve the purchase of goods or services from a vendor. So this is no different from that. So this is classic. And in all the campaigns that I've worked on, we see this happening. And in fact, in prior campaigns, we've sought advice from Helen Elliott to confirm that it is lawful, and we have emails to back this up, that it is lawful for a third-party vendor to write a check to a sign company to produce a sign for the benefit of the campaign. So this idea about whether it benefited the campaign and should go into a different bank account, you can't take that one sentence of the code and read it in isolation. You have to read the whole code together. The code allows in-kind contributions just like the ones we're talking about today.
Okay. Do you know of any other provisions of the codes or the regulations that talks about or gives an idea of, I think you mentioned a little while ago, the rules of the Board of Ethics. Do you know what rules you're talking about with regard to the definition of contributions?
Yes. The regulations of the Board of Ethics have, well, first of all, the charter allows the board to promulgate some rules to fill in some of the interstitial spaces in the regulations. And so one of the things that's been in that set of regulation, and it's been there a long time, I looked at this version, this is 2009, but I think it was there even before, is Section 3C, which is campaign contributions other than cash. And I think that's important because, again, the idea of the not money or, other than money, this is where they're defining campaign contributions other than cash. And they describe 3 or 4 different scenarios, including one that is very similar to this, which is example 2. Person Y, a contractor, volunteers to assemble and post signs on behalf of a candidate from materials provided by the candidate. Several of the persons assist the person Y in assembling and posting the signs, et cetera, et cetera. The value of person Y's services is not a campaign contribution, and here's what is important. Unless the services are commercial or professional services, however, the value of the employee's services is a contribution which must be reported as such. So example Y on page 4 of the rules specifically anticipates a third-party donor paying somebody else to provide services or goods to a campaign. And what does it say you have to do? You have to report it as such. And that's what the Keller campaign did. They reported it as a non-cash, in-kind contribution.
Right. Let me ask you about another section. And I apologize, I don't have that particular section of the rules ready because I did not know that you were going to reference that. But I do know that we've talked about Code 6, Section 6F of the code.
Okay.
And I think we've cited this in our legal briefs as well. I want to talk a little bit about that. Let me show that to Mr. Rogers.
Thank you.
Code 6F seems to be in the context of volunteer work hours, but it does state at the bottom there, the last sentence, if an individual volunteers during working hours paid by a third-party employer or the applicant candidate, then that employer makes an in-kind contribution to the applicable candidate. This is also regarding the need to report in-kind contributions of this sort, correct?
Exactly. The thing that the statute there or the charter is going after is unreported instances where somebody pays his or her employee to go out and work for the campaign. And, shocking, there's gambling in Casablanca. It used to happen, and maybe it still happens, that sometimes people of some wealth will have their employees go out and work for campaigns. And so what the charter does is it says, if you're going to have hiring people to provide services at the campaign, you have to report it as an in-kind contribution. And that's exactly what happened here. We have third parties essentially hiring Rio Strategies to provide both goods and services to the campaign.
Let me ask you a little bit about the solicitation. I think there was also a question from one of the board members about who solicits the contribution. Does it make any difference under the public finance systems as you've studied them and as you know? First of all, is there anything about who gets to solicit and who doesn't? And second, tell us your thoughts on that process.
No, in my review of the regulations and some of the other states is that it does not prohibit a candidate or the candidates committee from asking for or soliciting in-kind donations. To the contrary, I think that the idea of all these codes is to have the campaign involved in in-kind contributions so they can be properly reported. I don't think the public is at risk from in-kind contributions. What the public is at risk from is campaign or in-kind contributions made anonymously or in-kind contributions made in the dark. If I go buy $1 million of advertising for a candidate and nobody knows who did it. So what we're talking about here is trying to achieve transparency. And then the other thing is in our current legal climate after Citizens United and several cases that have taken out some of the parts of the city's code, I think there may be a First Amendment issue to say that a candidate may not solicit in-kind contributions, may run into First Amendment problems as well.
Is there anything that you see in the code or in any other of the codes that you've looked at which even talk about a prohibition against a candidate soliciting in-kind contributions?
Absolutely not, and we have asked the campaign auditor, Ms. Elliott, in previous campaigns whether it was permissible for the candidate to do that, and the response is always, as long as it's reported properly, that the services are valued at their actual market value, and they're reported on as an in-kind contribution, there's no prohibition on the candidate helping or doing whatever he can to solicit those things. I think there'd be a real First Amendment problem otherwise.
Do you see any documents or have you seen any documents or heard any testimony that would indicate to you as someone who knows the public finance systems that the Keller campaign somehow took more in-kind donations, something over the cap, for instance, or that they didn't report the contributions?
Clearly not. I think that there was a serious effort, a successful effort to comply with the 10% limit, and it appears that the accounting was very accurate, and it almost appears that they're being punished for doing too much accounting because they really gave a lot of transparency, and that's raising questions. But they were as transparent as one possibly could be about reporting these in-kind contributions in accordance with the charter and the regulations.
In all of the documents that you reviewed, and I think let me go back through that. You reviewed the complaint in this case and the responses.
And the attachments, yes, sir.
All the exhibits that were provided by both parties.
Yes, sir.
All right. In any of that information or those documents, or anything that you've heard today or seen today, indicate to you that there's any proof whatsoever that the Keller campaign received money contributions outside of the public finance money that he received?
Absolutely not. It was done in compliance with not only the spirit but the letter of the law, and in compliance with the way that publicly financed campaigns have been done since this system began.
We have 1 minute, Mr. Chairman. We have no further questions. Thank you, Mr. Cadigan.
Yes, sir.
All right, Mr. Rogers.
Mr. Cadigan, you don't mean to imply that you've looked at any invoices, bank statements, or otherwise to assure this Board of Ethics that Real Strategies has in fact reported all the checks they've received?
No,
right?
my testimony was that I reviewed the attachments to the complaint and the statement that were submitted here.
You haven't even reviewed any of the invoices or other material at the Keller campaign, right?
Other than what's been presented to the board today, no, sir.
And in the 2005 election, which you ran in for city council, I guess that was your second run,
Yep.
or was that your first?
Second, sir.
Second. The Voters Guide for the League of Women Voters of Albuquerque, Bernalillo County, puts out a summary, as they always do. And do you remember what was in that summary with regard to this taxpayer-funded campaign funds that candidates would receive?
I remember it because you attached it to the complaint, if I remember correctly.
Do you remember anybody prior to that vote, anybody, suggesting that it would be okay if, after a candidate receives $500,000 well, any amount, separate that, after they receive the taxpayer money, to solicit money from private donors and label it in kind for professional services and proceed to use the money as has been described today by Mr. Peckman and Mr. Keller?
Have I ever heard anybody suggest that? Absolutely. We debated that at this dais 2 or 3 times ad infinitum, and that system was borrowed from the Arizona system where it is clearly permitted.
In no brief and in no document has there been any suggestion of an Arizona actual case supporting what you're saying. Did you miss that, or did I miss that?
I noticed that no one cited any Arizona cases. I'm not sure that there are any Arizona cases. I'm referring to what used to be called Proposition 200, which was the Arizona public finance law, which is the granddaddy of public finance laws, from as far as I know.
So when the league tells voters in exchange for getting disbursements from the fund, candidates would not be allowed to accept or spend private campaign contributions, voters were supposed to understand that candidates could get another $38,000 through this process of private persons writing checks to a campaign operation. Is that right?
I guess I would question why the League of Women Voters' incredibly brief summary of the very complicated open and ethical elections charter amendment would have anything to do with anything, but it was a very brief summary, and it probably left out, well, it did, it left out many, many, many provisions of the ordinance, which are complicated and lengthy.
And you think voters were aware of what you remember now about that debate as opposed to what the League of Women Voters provided to them. Is that correct, Mr. Cadigan?
If you want my opinion on what voters were interested in, they were interested in getting big developer money, e.g. Santolina or Westland, what they were called then. They were interested in getting them out of city politics because the developer money dominated city politics until the public financing became a reality.
And so the $50,000 from the unions for Mr. Keller's Measure Finance Committee, that isn't considered big dollars, is it?
I don't know about $50,000, but if it's in compliance with the law, it's in compliance with the law.
In-kind contribution says a good or service other than money, right?
Yes, sir.
Thank you.
Any further questions from the respondent?
Nothing further.
Okay. Do any of the board members have questions for this witness?
Thank you.
All right, Mr. Cadigan, thank you very much. All right. Does the complainant have, does the respondent have any other witnesses?
We do not.
Okay. Rest. So you rest. So are there any further witnesses on behalf of the complainant?
No, Mr. Chairman.
All right. We're going to move into closing presentations then. Time-wise, here is where we are. The complainant has 10 minutes remaining of their 90. The respondent has 28 minutes, 30 seconds. So, Mr. Rogers, the floor is yours.
It's black and it's white. There's no confusion about this. In-kind contribution means a good or service other than money. Here is the intent of the ethics provisions. It's also in your exhibit book. Every time Mr. Keller, Mr. Packman, or his fine attorneys talk about all this stuff, they skip directly to public financing, and they want to argue that that's a swell thing. That's not in front of you. What's in front of you is the plan to take $500,000 and on top of that, take cash from private donors, tell them to send a check to this entity that's not directly regulated by you, didn't want to produce their documents, didn't produce their documents to show where the money actually went. How does taking that $37,000, that extra $37,000 on top of $500,000, how does that diminish the public perception of corruption and strengthen public confidence in the governmental and election processes? To ask the question is to answer it. That's $37,000 that they're not entitled to. $500,000 is a whole lot of money. They're not entitled to do what they did. There is no document supporting the proposition that anyone has done what they have done in this instance. None. This is simply taking cash and using it however Rio Strategies decides that it wants to use it. This is a violation of the reporting requirements. There are 51 instances where they have mislabeled professional services. And you saw their invoices that they prepared. Not a single invoice is for professional services. This was a cover-up. Look at the date. Look at the date that invoice was prepared. It was prepared immediately after the complaint was filed. KOB story on the 7th, complaint filed on the 8th, invoice which wanted you to think that these were goods was prepared by Mr. Packman after September 8th, and it was dated August 1. Furthermore, this idea that well, you know, maybe we're not sure, but it's a better system anyway. Good heavens. They are using 2 bank accounts. The rules say 1 bank account. They say that so that you can audit, you can look at those invoices and so on. It says any contribution for the benefit of a candidate. There can't be any confusion that these people thought they were contributing for the benefit of Mr. Keller. That money was placed in the Rio Strategies bank account, and yes, it was laundered and it was tumbled, and what came out, you have to trust someone who is not subject to these rules. It should have been, the campaign needs to be responsible, and they reported those cash donations, money, improperly. They took an additional $37,000, and if you find that there's been a violation, if you don't, consistent with that, find them that money, they're still ahead, because this end run that they've attempted is going to be successful unless there's a $37,000 fine and a reprimand. And the reason that has to be done is everybody's watching. This isn't a case about public financing directly. This is a case where they took money on top of that. This isn't an attack on motherhood or apple pie or anything else. This is a violation of that specific requirement. That invoice tells you everything you want to know, just as you tell a kid's growing up. One lie leads to another. One false statement led to that false invoice. That tells you exactly what they're nervous about. You saw Mr. Packman finally admit that Diane Denish was concerned about this. This isn't some plot by a disgruntled former campaign manager or his attorney. It's been described by Mr. Keller. This isn't that at all. This is a basic violation of these rules. How much money do you need? How much money does the system allow? $500,000. $37,000. And on top of that, they immediately went out to get more. And it is not consistent. There has been not a document suggested that anyone has tried this before. All of those notes suggest specific payments to a specific vendor for a specific good. That's it. And anything, even that, is inconsistent with the advisory opinions. You know what the process is. They know what the process is. They didn't ask because it's easier to ask for forgiveness or assume that you weren't going to fine him $37,000 than it is to ask the question in advance and hear what you have to say. For those reasons, we believe it is black and white. It's this easy. That's $37,000. That is improperly solicited, improperly reported, improperly placed into somebody's bank account. And I'm asking on behalf of the voters, I'm asking on behalf of the citizens that you indicate that the rules apply to everybody. They apply to everybody across the board without regard to whether you're the auditor and now think it's okay to do things like this, or anybody else up and down the line. Thank you.
Before you sit down, do any of the board members have any questions for Mr. Rogers?
I do have one question. You put up that chart on section 4 on, I think it was contributions. Where is that from?
That's from the Article 16. And do you have my notebook? The notebook,
yes,
the exhibits?
I do.
Exhibit 1 are the excerpts that are relevant to this proceeding. Okay. And if you look, I put Article 16 first, and I think it's the second page of Exhibit 1 there.
13.
Oh, is it 13?
Yes.
That's why 13 is relevant.
It's section 13. And do we have that as part of the package?
Hopefully it's there. Look at, let me see.
13, yeah. Okay, I have it.
Are there any other questions? Mr. Rogers, I have one. I want to pick up on Mr. Cadigan's donut example. So, under your thinking, if I'm a volunteer and I stop at Dunkin' Donuts and buy a dozen donuts and then go to the campaign headquarters with my donuts. So number one, is that are the donuts an in-kind contribution to the campaign? And I do this entirely on my own. I'm just on my way to the headquarters and see Dunkin' Donuts.
It's difficult because, contrary to what you may believe, I think there are de minimis issues that never deserve your attention. And so the answer is, I think there's a difference. I think there's a difference between a volunteer who, well,
here, to try and keep things apples to apples, suppose I buy a dozen donuts. I stop and buy 144 donuts. So I have 12 boxes. I stop at Dunkin' Donuts, and I've done this entirely on my own. My first question is, are those donuts now an in-kind contribution?
Yes, and I think that's what in-kind is all about.
Okay. And if they are, then how should the candidate report voluntary contribution of those donuts?
That is what's meant by in-kind donation. In other words, what the rules say is that an in-kind donation is considered both a contribution and an expenditure. That's what the rules say. And so what in-kind is intended to cover, what in-kind is supposed to address. Someone throws this party that Mr. Keller was talking about, and they gather all the supporters. And at that party, they provide soft drinks or beer or all sorts of stuff. Okay? That's the classic in-kind. Now, I do not dispute the proposition that a printing company could call and say, I really like your campaign, I think this is wonderful, and I'd like to give you some printing, and it's worth approximately X. That's in kind. I think there's a whole bunch of goods and even services, but none of these persons contributed professional services.
But my question is, how should the campaign, or does the campaign need to now account somehow for my 12 dozen donut contribution?
I think that's an in-kind contribution. I mean, how would you separate that from, champagne and filet mignon for supporters and so on?
So it should be accounted against whatever the cap is on in-kind
Absolutely.
contribution?
Okay. Yeah.
And my last question is, and I took this down from your comment in your opening statement, because I counted, you said this 3 times. The reason I gave my hypothetical about me being just a softie for donuts and doing this entirely on my own, does it matter for your position whether these are voluntary, my hypothetical, as compared to the words you used, contribution solicited from the candidate? In other words, the candidate calls me and says, will you please pick up 12 dozen donuts on your way to my office? For purposes of your argument to the board, is there a difference whether they're a voluntary or solicited directly by the candidate?
No, there can't be, and I don't think that anyone would argue to the contrary, because if somebody shows up at the Keller campaign with 200 printed mailers of all of his campaign promises and so on, I mean, the idea that he just drops them there, wasn't asked, but just drops them there, if they're used, like the donuts are used, I think it's a contribution. But luckily, I don't think we're talking about de minimis matters. I think we're talking about significant things. Thank you, Mr. Chairman. Thank you for your patience, and once again, thank you for your public service.
Okay. Thank you for answering the question. For the respondent.
Thank you. Thank you, Mr. Chairman and members of the board. I'm going to move Mr. Rogers' demonstratives. Although I do agree with him that I think that this is a black and white case, in that it is clear that Mr. Keller did nothing to violate any of the code or charter amendments in this case. Instead, Mr. Keller's campaign received approximately $38,000, or 10% of the publicly financed money that he received in the general election as in-kind donations. And the hyperbole aside, the complainant's case falls apart because there are 2 fatal flaws to it. First, there is no allegation, no evidence to suggest that Tim Keller or the Keller for Albuquerque campaign received the money that was at issue here. The testimony is unequivocal, uncontested, that the money, the checks that are at issue here, went to Rio Strategies, which is a third-party vendor of the Keller for Albuquerque campaign. You will see from some of the exhibits that we submitted that Rio Strategies is an independent campaign management firm that provides a bundle of services to its many varied clients. It is not the Keller for Albuquerque campaign. And so I was listening to Mr. Rogers argue, and he did something that mentors of mine like Joe Goldberg have tried to sort of beat out of me, which is use pronouns in a somewhat unclear way. And he kept on saying they received money, they received this cash. Well, we have to be very clear and very precise in this case. And the only evidence, the only credible evidence, separate and apart from speculation or argument by Mr. Rogers, is that Rio Strategies was the recipient of the money that is at issue here. So for the complainant's case to have any teeth, we think it fails for other reasons, you would have to believe that the Keller for Albuquerque campaign was receiving these monies that are at issue. And there is just no evidence of that. In fact, the overwhelming evidence is exactly the opposite, that it was Rio Strategies, this third party, that was receiving it. And then the in-kind donation or the in-kind contribution was these individuals, these donors, paying for Rio Strategies' professional services. Now, Rio Strategies invoiced, and I would take issue with Mr. Rogers' testimony about that invoice. I think Mr. Packman was clear that that invoice that began on August 1st and that it was a work in progress, and we've seen different iterations of that invoice. I think that's quite typical when you're dealing with vendors. That's certainly true, for example, our CPA, when we're dealing with our CPA. There may be different drafts of an invoice. But that Rio Strategies and the Keller campaign agreed that to be entirely transparent, to make sure that everyone knew what was going on, in case there are any questions, that Rio Strategies would invoice, would submit an invoice in Invoice 46, what that money that those donors gave to Rio Strategies, what that money went to. And that's what they did. And I think as Mr. Keller testified, and as Mr. Cadigan testified, that's a much cleaner way of doing it. Rather than an individual, for example, loaning a car to a campaign, and then the campaign being in the very difficult position, I think, of trying to contemplate and sort of estimate what that service or what that good should be valued at, what that service of the loaning of a car should be. How do you do that? Do you call Hertz? Do you call car rental services? It can get very complicated, and I think as Mr. Cadigan testified, the evil that these rules are meant to prevent is the idea that that campaigns are getting sort of a flood of undervalued services and goods. And so the way that the Keller campaign did this, by directing people who were interested in providing some support to the Keller campaign, because the Keller campaign could not receive money, to provide donations to Rio Strategies to provide as in-kind donations, and then Rio Strategies would provide those services. The other fatal flaw to the complainant's case is this notion that money is money and there can be no money when you're talking about in-kind contributions. And I think the chairman's questions to Mr. Rogers, I think, actually drilled down exactly to that point, and I think that was an extraordinary but accurate admission by Mr. Rogers, that in fact money is always involved, even if you're talking about in-kind contributions, because someone is not going to happen upon a wheat field and then happen upon a bowl and then stir up that wheat, whatever you do to make donuts, I'm a terrible cook, and all of a sudden sort of present those donuts to the campaign. There's always going to be money involved. That individual, whether it's someone who just, for the good of their heart and their interest in helping the Keller campaign without any solicitation, or if directly asked by the campaign, goes and buys donuts, there is a cash transaction there. There is a money transaction. But the in-kind contribution is that good that then goes to the campaign. So it's not cash going. It's not money handed over to the campaign to say, oh, here, go buy some donuts. It's the individual purchasing those goods. Well, as we know from the code, from what we've cited 6F and 3K, Section 3K, the code allows for in-kind donations of not just goods, not just those 12 or 144 donuts, but also services. The code expressly contemplates that. And there are examples throughout the code of what that means. So I think the greatest example, which we cite to in our brief, is this idea that if an individual who owns say I own an IT firm, and my employee is volunteering providing IT services to Keller for Albuquerque. Well, I, as the owner of that IT services, am making an in-kind donation of that employee's professional services. I'm the donor. I, the owner of the IT company, am the donor because I'm paying that employee to provide those professional services. It's directly analogous to this situation where you have individuals paying for the professional services of Rio Strategies. So again, the two sort of foundations that the complainant's case are built on are flawed, are fatally flawed. One, Rio Strategies and Keller for Albuquerque are not the same entity. They are two separate entities, and there's no evidence that any money went to Keller for Albuquerque. And two, of course, there is the contemplation of money being a part of in-kind donations. It doesn't make any sense otherwise. But the way that the Keller campaign did it is permissible, and we submit preferable to perhaps how other publicly financed candidates have done it. We ask you to obviously closely read our brief. We believe that our brief lays out the law very clearly. We cite to other jurisdictions that have grappled with similar issues, and those jurisdictions come down on our side on this. And we ask you to, at the end of that evaluation, thinking about the evidence that you heard today, to dismiss this complaint in total and to end this process. Thank you.
All right, thank you. Let me raise two housekeeping matters with counsel. First is the question of each side's notebooks that you've provided to the members of the board, provided to the witnesses. I am assuming that everything in those notebooks there are no objections to, and that the clerk will keep each of those notebooks as part of all the documents submitted in this case. Is that correct?
Mr. Chairman, the one question that we have is Mr. Rogers circulated a summary. It was an exhibit that was a summary of the campaign finance reports. I don't know if that's included in your notebook.
Well, you have a copy of the notebook.
We do have a copy of the notebook.
Please look at the notebook. I need an answer to that question.
Okay.
Is the documents that are in the notebook that were distributed. So, Mr. Rogers, is my assumption correct as far as the complainant goes?
Mr. Chairman, there was one objection, and it goes to the documents supposedly concerning R.J. Berry. What they've submitted is not the report from R.J. Berry's 2009 campaign, but a summary that does not contain the same information that's before you from Mr. Keller. Let me explain what I mean by that.
Well, I'm going to cut you off right there. I believe you're talking about Exhibit D.
I'm sure you're right, Mr. Chairman.
You have a copy of the notebook, Mr. Rogers. You can make this go a little faster if you actually have in front of you what we're talking about. I'm looking at Tim Keller, BOE hearing, November 8, 2017, Keller exhibit. Do you have that notebook?
Yes, that's it, Mr. Chairman.
Exhibit D, Richard Berry, 2009 campaign finance reports.
Yes.
Okay. No witness was ever asked a question about these materials.
And I disagree with Mr. Rogers' characterization, but we would withdraw that exhibit.
All right, so Exhibit D should be removed?
Yes.
Are there any other exhibits that should be removed? Let's start with the Keller notebook since we have that in front of us.
No, we would.
Okay. Mr. Rogers, are you okay with this notebook with the exception of Exhibit D, which will be removed?
Yes, Mr. Chairman.
Okay. Now let's turn to the other notebook that was given to us. This is Wayne Johnson's hearing exhibits, evidentiary hearing. There are exhibits. Are these exhibits fine as is?
Our objection is that we have not, we received what I believe is Exhibit 3, which is this summary that Mr. Rogers compiled, and we just haven't had a chance to double-check it against the
Okay,
reports
again,
to make
I'm
sure
going
it's
to cut
accurate.
you off.
Yes.
Exhibit 3, no, my recollection is no witness was ever asked a question about Exhibit 3. Is that correct?
That's correct.
All right, so with that objection, Exhibit 3 will be removed. No witness was questioned about it. There is an objection. It's too late to bring this up now. So Exhibit 3 will be removed from this notebook. With that removal, are these exhibits good to be included in all the materials?
We have no further objections.
All right, so we will do that. So last housekeeping matter, which is, I told you at the very beginning, I wanted to raise the issue of timing. Just a general question. What are the parties' preferences with regard to how quickly this board rules on this complaint, given that there is the other matter which raises a substantially similar issue, which will be heard on November 17th? So from the complainant.
I think it is critical, Mr. Chairman, that this be acted on and determined at the earliest date, hopefully today.
All right, respondent.
I think as the chairman, as Mr. Chairman, as you indicated at the beginning of this, given that this board's powers are limited, it's not as though Mr. Keller, even if the board found against him, he could be removed, for example, from the ballot.
I just need an answer to my question.
We think it's more prudent to wait until after the board has heard all the evidence in both of these cases.
Okay, thank you. So with that being said, both cases are closed. I'm going to ask Member Throckmorton to say the magic language.
I make a motion that the board go into closed session pursuant to New Mexico statutes, section 10-15-1, parentheses H, parentheses 3, to deliberate on the evidence received at the hearing held before the board in case number 08-2017.
Is there a second to that motion?
I'll second, Mr. Chairman.
Okay, is there any discussion? All those in favor of the motion indicate by saying aye.
Aye.
Okay. Motion is passed. We will go into closed session. Thank you very much. All right. The board is back in open session at 2:04 p.m. We had a closed session pursuant to New Mexico Statute Annotated 1978, Section 10-15-1, H3, to deliberate on the evidence received at the hearing held before the board in case number 08-2017. It is the sense of the board that we are recessing for the day. We will reconvene hopefully no later than Monday at a time and place to be announced in due course after we've had the opportunity to consult with the city clerk as to a location. At which point, when we reconvene, we will return to closed session. think that's right. Yes, we will return to closed session so that we will be in a position then to take a vote and announce an opinion in 08/2017. So at this point, I will entertain a motion to recess.
I'll move to recess.
Thank you. Is there a second? Great. Is there any discussion? All those in favor of recessing, say aye. Aye. Any opposed? Great. We are in recess.